All right, I think we are. Whoop, one more thing. Ready to go. So we have a criminal trial calendar that runs next week. So Monday morning, whatever cases are coming in for jury selection. And we're going to figure out today which cases are going to be on that short list. And it sounds like we also have a few pleas. I'm seeing we don't necessarily have some of our main players here. Is Ms. Davis heading this way?
Just text her, Judge, to get her ETA.
All right. And Ms. Rios, I know that's not your job.
I will text her.
You will text her. Excellent. Mr. Williams, are you able to hear us? You should be at Riverbend. You can just wave your hand if you can hear us. Great. All right. Once your lawyer's here, we can talk about your situation. And who do we have who is at Jackson at Georgia Diagnostic?
Lemons?
Oh, hey, Mr. Lemons, what's going on?
How you doing now, sir, this morning?
I'm doing fine. I think we can excuse you. Let me just double confirm, because I know we resolved, so when you were last on with your lawyer, Mr. Glenn, we took care of business, and I bet we forgot to withdraw the ticket with GDC having you join us. I'm not aware of any other business you had. We had that plea, and I think you're good to go. Do you have any questions about anything?
Something about when I had seen the parole peoples down here, and they were saying something about my credit, that I was locked up since April. They said it never hit the system, so they never gave me no type of credit since I've been down here. So they were saying something about I had to max out my time. I wasn't eligible for parole, and because they said I didn't get no credit from when I was locked up. But I remember you saying, credit for time served. I remember that part.
Sure. So you should reach out to Mr. Glenn and let him know your concern so he can have a quick conversation with either pardons and parole or GDC to see what the confusion is on their part. And if there's something I need to do, I'll be happy to reach out. But you should start with Mr. Glenn, okay?
Yes, sir.
All right. So thank you, GDC. Mr. Lemons is free to go, and I don't think we've got anyone else down at Jackson. Ms. Willingham was saying you're ready on all the cases, Ms. Davis.
I thought she worked out pleas in all my cases.
Yeah, now there was no Ms. Rios to work them out with. And all that Rios does is say, Ms. Wood's ready for trial, so easy passing the baton. All right, I already explained to everyone else in the room what we're doing this morning, which is calling this calendar to figure out what's happening Monday morning. Positions 1 through 3 are Michael Jordan.
I am expecting him. I will give him a call. It was really bad.
I gather. And your expectation is that his 3 cases are resolving today? Okay, great. So when we're done with the call of the calendar, please check on him. Next up is Mr. Tewitt. Good morning, Ms. Fagan. How are you?
I'm doing well.
Great.
I will be ready.
Good. I want to be ready on this. I know Mr. Abate has been tied up on another case, but the DA's office needs to be ready to go on what is the oldest murder on my docket.
Yes, Judge. We have notified MC. However,
who's major case?
Yes.
Okay.
But, we don't have any other updates. Mr. Abate is the only person that maintains his caseload. But he is aware that it's on. So
okay.
And I have notified them based on pretrial that we expect that this will be first out.
Okay, I appreciate you passing that on, and hopefully that team is coalescing to support. Ms. Fagan, Mr. Truitt is here and he's up. I'm happy to bring him out to tell him the situation. Tell me how you'd like to. We have prosecutors here, so it's fine for me to engage with him.
The only issue that I have is I have a 6-minute video that you gave me an order. I've been to the jail, you've seen everything, but this one video I needed internet for. So either maybe I could get in.
We'll do it here.
On Monday, or
We could either do it on Monday during jury selection, easy. Or I bet we could do, if it's only 6 minutes, I bet we could do it here today. Yeah.
but I didn't know if we had what this situation was.
Well, let's see the flow. If you're good sticking around this morning, but you should assume that this is first out on Monday, and that would be jury selection. I know you're not the prosecutor. You feel like it's a 1-week case. If we get the jury all on Monday, we ought to be done by Friday,
I think so.
barring surprises.
I intended it's close to arrive this morning.
Pardon me?
I intended for it's close to arrive this morning.
Great. Okay, that's great. I'll actually be sending an email out today to the lawyers who will be on the short list for Monday that'll say close by noon tomorrow. But if they're here today, we have a place to store them. So that's great. Okay, thank you. Mr. Palmer has resolved his cases, and I think Mr. Jordan came in. Hey, Mr. Jordan, good morning. Troy Britton. Ms. Britton is here, and I have an update. Ms. Brown is sending the attorney agreement to the attorneys. As soon as they get that back, they can do the order of admission. Something about, did you get some emails, Ms. Rios? Because now they're saying they don't have the medicals, but you told me she did.
She went to go do her medicals, but Ms. Brown called me this morning as I was walking in. And so what they're gonna do is admit her to drug court and transfer it over.
Okay, that's what I'm seeing here. So I think we can go forward then today. They did get the GCICs this morning. I asked if Ms. Britton could be at the front of the line. They looked at it, little exclamation point next to the ag assault. I said, the state and the defense have been talking about this. That doesn't mean you have to let her in, but you should check it out. And they did. And it sounds like it's all a go. It may be a pivot into BHTC, assuming the diagnosis comes from Grady.
Yes, sir.
Okay. All right. Great. So we can handle Ms. Britton's cases. That gets us to Anthony Cook. Mr. Cook, are you here?
Good morning, Judge.
Hey, Ms. Rockwell, good morning.
I was going to apologize for being late, but maybe I'm not late. Thank you so much for the platform. I'm going to be present, and he's on his way also. He's disabled, but he's coming, and I want to just see if the prosecutor has a moment and if we can try to resolve this today, Judge.
Great. Ms. Davis, I'm sure we'll have a moment for you. We're here all day. We're good till 11:30 this morning, and then we'll pick back up around 1. So we'll get done what we can by 11:30. Whatever we don't, then we will return around 1 to take care of the rest of it. So we will await your arrival, Ms. Rockwell, and Mr. Cook's.
Thank you, Judge.
You're welcome for the platform. Stanley Roberts. Hey, Mr. Roberts, good morning. Any idea where your lawyer is? Great. If you don't mind stepping outside and giving him a ring and then giving us the ETA for when he'll be here, that'll be helpful. Thank you. Dontavius Wright. I don't know, Ms. Nelson, I guess if you could check with Mr. Johnson to see if he could hop on the Zoom even, so we could get an update from him. I think we know why we're in a holding pattern, but he may know something more than the state does.
Okay, we'll do.
Thank you. Okay. All right. Broderick Leap.
Yes, Judge, my understanding is that, he has already been excused, Lord Dobbs covering for Ms. Wood.
Thank you for being here, Mr. Dobbs. I appreciate it.
Yes, pleasure to, be here. My understanding is that, there is an agreement to reset this case and that Mr. Leak has been excused from appearing today.
That's right. I just saw my notes. The state has a witness who's unavailable and somehow is going to be unavailable for the next 2 years, but we're not going to reset this for 2 years out. It will be set down, and Ms. Wood knows this. It will be on either the November or the December trial calendar, and that's when we'll try it. We just need to work through the witness replacement. So Mr. Leak was excused.
Thank you.
All right, Anthony Johnson. Hello, Mr. Johnson. I'm okay. So this one, the response I got yesterday from Ms. Rios was a little more confusing about what we're doing. He has 3 cases.
Yes, Judge.
He is on the consolidated trial calendar for not next week, but the week after. And then he's on this trial calendar. What do you have?
Right, so, my understanding is that, Ms. Wood has been attempting to get Mr. Johnson into the next level boys, academy. At this time, I'm not sure if he has been accepted or not. Ms. Wood, has requested that I ask for a one-time continuance. She, points to the fact that 2 of his cases were only indicted in May of this year and that she's trying to resolve all cases at once globally. So she is asking for a one-time reset on this offer.
Okay.
Or on this matter.
Right. That sounds like a familiar request. Okay. Why don't you check with Mr. Johnson after we get through the calendar to see if there's any update on next level? How old are you, Mr. Johnson?
5.
Okay. So it might be next level Big Boys Academy. I don't know if there's an age limit for that. And we'll see where it's going. I'm trying to see how these charges fit into that, but I'm sure there's a backstory to all this. So Mr. Johnson, if you'll take a seat, Mr. Dobbs is going to talk with you briefly and we'll figure out how we're moving forward. Mr. Darcy shouldn't be here. Your case was resolved. Ms. Bernard, also your case was resolved. That gets us to Anthony Smith. Mr. Smith? All right, well, we'll call that one more time. How about Ms. Fletcher? Ms. Fletcher?
Absolutely.
Okay, do you have contact information for her?
I do, and I will, reach out.
Great. Mr. Chasner?
Morning, Judge.
Good morning.
Mr. Chapman's here, and I've tried this with Ms. Davis, and my client is still undergoing some psychiatric care related to this issue. We're close to a plea, so he will be done with the treatment first week in November. So we're asking over 6th of November if it would get resolved.
Why don't we talk after I call the calendar as to why we can't go forward now? You can explain more. We'll have a conversation.
Okay, thank you, Judge.
Mr. Stafford. Good morning, sir. Mr. Dobbs.
Yes, Judge, our announcement is that we are ready for trial.
All right. Have you, I know you are subbing in for Ms. Wood, but would you please have one last conversation with Mr. Stafford, whatever the state's offer is, so I can know that, in fact, Mr. Stafford wants to come back Monday morning and has all week next week to give us, so we can try the burglary. And if that's what he wants to do, he's got a right to do that. I guess technically it might be Tuesday. I think Ms. Wood will be back in action Tuesday. But have one more conversation with Mr. Stafford after you've spoken with Ms. Davis, and we'll close that loop.
Of course, thank you.
All right. Ms. Mann.
Judge, Ms. Mann got in contact with Ms. Rios this morning and he's running late.
Okay. All right. Crystal Alexander.
Pass the whole to the end of the calendar, I will reach out.
Okay. Alburn Johnson.
Good morning, Judge. Hope you're doing well. There's still that Daubert promotion that needs to be heard in this case, as well as some outstanding DPW records, so we're waiting on those.
I know about the Daubert. DFAX records, had you requested them and you didn't get them? Or I'm not sitting on any DFAX records.
Not that I know of, but we're going to be sent through the court. So I think I'm waiting for you to receive them and then find out if there's any relevant.
Right. Okay, and we may need to have a conversation before I look through them so I know what lens to be using. But you've made a request of DFAX to get those because they usually come. We had our hearing a while ago, and I thought you were requesting them. I want to make sure there's something I haven't sitting on my desk that I need to sign.
Yeah, I think it was just the court sending an order to DFAX in Muskogee County and then complying with that and sending those records back to the court.
Okay, boy, I hope it hasn't been stuck because I didn't sign an order to get them, but I'll look into that. Ms. Clark?
Judge McBurney, hi. So I requested the records, and I think I sent them to you under seal to Ms. Nelson.
Okay.
So you should have all of the records related to.
Excellent. So you got them, thank you. And they're here electronically?
Yes, Your Honor.
Okay.
You
And
need me to print them out?
no. I'm fine with how they were delivered. I just want to know if I'm looking for a stack of documents or a file. And it sounds like it's a file. I will track that down. And then Mr. Jones, you and I can have a conversation ex parte about what you think I ought to know as I'm looking through them so I don't miscategorize something as not relevant when it might be. Okay? I want to share this idea about the Daubert hearing. My understanding is you are challenging basically the forensic interview.
Yes, Judge, essentially the methodology.
So I've been through one of these recently, and I'm not sure that we need to have a full-blown hearing so much as, but it's up to you. I think that I'm in a position to assess. Well, it's two things. I don't think you've got a particularly powerful legal argument that the framework that is used in these interviews is subject to attack under 702. The question would be, was it applied consistent with the teachings? In other words, it's a framework that has been tested and approved and is widely used. And it's also not something that yields reliable versus unreliable results because you're not mixing chemicals to figure out what's there. It's a way in which someone interacts with someone else. And so what I concluded in a very similar scenario was it really, you need to watch the interview. And if there are lots of leading questions in the interview, then the interviewer is not properly applying the framework as it's taught. And as I'm sure the interviewer would narrate, she or he was taught to do it. And so my proposal is that if you all agree to admit the interview for purposes of the 702 motion only, so you're not conceding that it's admissible at trial, so that I can review it. If there are parts of the interview that you want to bring to my attention saying, look, this was inconsistent with the methodology, then you could flag that. But really what I need to do is just make sure that the methodology was appropriately applied to the interview. That's a way I think we can streamline it, but I guess we need to work through that. Is this the one where the interviewer is in Hawaii?
Yes, Your Honor.
And she is willing and able to travel, unlike our Colorado person, but Hawaii is the new home.
Yes, Your Honor.
Okay.
And she's a forensic interviewer for the U.S. Army.
Okay. That was not her role at the time of her work in this case.
No, because she was she worked for a treehouse, children's treehouse out of Columbus, Georgia.
Okay. Got it. So Mr. Jones, as long as the state has disclosed as they need to, their expert disclosure, this was the methodology that was used, If it is the one that I suspect is used in 98.5% of all these interviews, I'm comfortable making a ruling on the reliability of that methodology if properly applied, which leaves us with the as-applied challenge. And I'm not asking you to articulate the as-applied challenge right now, but I think what that means is we can watch the interview and we can watch it here in court, or like I said, you could agree that it's admissible for purposes of the motion only, and then I could review it, and then I'd be open to you saying, look, if you go to minute 7, from 7 to 8, I'm challenging that. That's where there was a defect in the application of the methodology.
My initial reaction would be to still have the interviewer come in person. I understand she's in Hawaii.
Well, set aside where assume she's in Decatur. Why would we need her here?
To answer a question as to her interviewing techniques and just figure out exactly where she's coming from with the questions, opposed to just looking at the questions.
So, what I'm going to ask you to do is let me know, and Ms. Clark, and put in an email what it was about the interview that you want to ask her about, as opposed to you've watched it and there are things you want to that you want to bring to my attention that we're talking about 702 here, not something different. And I'm telling you, I don't think there needs to be a hearing for that witness to say, child first. I don't know which one she used. The state needs to tell us which methodology she used, but assume it's child first. To me, you challenging that is like you challenging fingerprints. We're not going to have a hearing on fingerprints. I will make a finding that the science of fingerprinting, if properly applied, is something that has been deemed reliable and passes the 702 test. I've already made that finding for child first in another case. The methodology hasn't changed from that other case. So that finding is going to carry over. That leaves us the as applied. Did you actually properly apply this methodology that I'm telling you right now passes 702 muster? I don't understand why we need the interviewer here for that, because that's us watching the interview and you'd be able to, look, there's a leading question. She cut the kid off. She starts putting words in the kid's mouth. The kid said, I don't remember. Well, what about this? And doing things that are inconsistent with the methodology. I'm not saying that happened. You need to hope it happened if you want the interview to be excluded under 702. But I'm less focused on Hawaii than I am on, because you don't have a right to a hearing. You have a right to a ruling on it. And I want us to be efficient with it. And having very recently been through the child first argument and we're fussing at this person, is it a valid methodology and this and that, I've addressed that. If I'm wrong, I'll be wrong in both cases. But what we're left with, which is unique and distinct to Mr. Johnson's case, is how was it used in this one? Not what is it, but how was it used? And to me, that gets down to, well, now we've got the interview. That may be when I watch the interview, I'm scratching my head too. Like, you know what, we need to get her here. Whether it's we get her here on Zoom or what. But I'm going to ask you to look through the interview and let me know if there are areas that you want me to focus on because you had concerns about the reliable application of the methodology. And we're going to work through it that way. And I'll note your objection, but I think I'm on solid ground not having a hearing. I'm not required to have a hearing. But I do leave open the option of pivoting to a hearing if when I see the interview or because of things you raise, like, yeah, you know what? I don't know how to resolve that concern you have. I've watched it. I also want to get input from the interviewer to understand, well, what happened right here. I'm not seeing how that was consistent with the methodology.
Very well, Judge.
Okay, I will check on the DFACS records, make sure I've got them. No reason to doubt Ms. Clark. If I do, I'll arrange for the two of us to have a conversation. And then I'll also look to you to identify the areas of concern in the interview. And you may say, you know what, I'm not pointing anything specific. The state has to demonstrate that it was reliably applied. So I need to watch it in advance. And I'm committing to doing that.
Thank you, Judge.
You're welcome. Ms. Clark, if you recall, how long is the interview? Am I committing to watching a 7-hour interview or
Your Honor, it was, I think each interview
each?
was about 30 minutes.
How many
It
interviews?
was 2.
Okay. Both with the same interviewer
Yes.
on the same day or different times?
I think it was this, I want to say it was the same day because, there's a part where the interviewer,
Steps away, I gotta go talk with some friends,
if it's anything.
and then they come back.
So based off of the disclosure, by the minor child, it wasn't clear based on what she was saying, where the jurisdiction lies.
Okay. I just, it's 2 interviews, it's probably the same day, it's just, it's,
Oh, they're wrong.
I'm not mistaken.
okay. They are what they are. I just was curious why there were 2. So there was a follow-up. Okay. Mr. Jones, I think those were the 2 pieces. There was defects records and 702, which is why we won't reach Mr. Johnson's case on this calendar. Anything else you can recall?
No, Judge, that's everything.
Okay.
There's nothing else from the court, me, my client and myself being excused.
Yes, sir. And Mr. Johnson, I appreciate you being here. You remain subject to all the conditions of the bond you're under. If for some reason you feel like they need to change, make sure you reach out to Mr. Jones and we can always have dialogue about modifying the conditions if I think that makes sense. Okay? All right. Thank you.
I'm good with that.
You too.
Judge, my apologies, before you move on to the next case.
Yes, ma'am.
I am being summoned in Judge McAfee's courtroom. I understand that Mr. Johnson, he did email back and say that he's gonna hop on Zoom, but I cannot wait. My announcement does not change. Ms. Davis has it, in regards to Mr. Wright not being ready based on the competency evaluation. But if I may be excused to go down to Judge McAfee, I would greatly appreciate it.
What's happening there that's more important than a trial calendar call?
Trial calendar call there.
Oh, okay.
And motions hearings, but your calendar, I only have 1 case, and there I have a total of 4.
Okay.
So it made more sense to come here first.
I appreciate you being here. You should go.
Thank you.
All right. That's almost it for the calendar. Jairus Talbot. Good morning, Mr. Talbot. I don't think Ms. Cabrera can be here today. It was important that you were here today.
I talked to her. I haven't even talked to her. Texted me. That was it.
Okay. Was it a good text?
She just told me about the plea, and I told her I'm not taking the plea because I'm not guilty. So
Okay. Well, she had a leave of absence, so we're not going to be able to reach your case. I appreciate you showing up. You needed to show up, and you will get notice of when the next trial calendar is. Before then, you and Ms. Cabrera need to talk more.
if they're like, I have to go on the whole, like, as far as with the DA has try to compare it or, I don't know any rules.
Okay. What I'm going to do is reach out to Ms. Cabrera and ask her to connect with you more so than just on a text. She was on a 7-week trial right next door during the time that she would have liked to be connecting with you. So I'm not making excuses for her. She's hardworking and busy. Rarely do you get stuck in a 7-week trial, but that left people like you, her other important clients, a little bit behind. And so I don't want you to be thinking, I got this lawyer who doesn't care. That is not Ms. Cabrera. But a 7-week trial turns everyone's world upside down. That is over. And so she needs to connect with you to answer your questions, show you the discovery, et cetera. And she shared with me your confusion because heck, you lived at the Pencil Lofts. And so you being near the CSX rail yard is well, I live there. I go to bed near the CSX rail yards. So she and you will talk, and then she'll talk with Ms. Davis about whatever it is the state thinks connects you to what was going down. Because there's video footage of these guys breaking into, not you necessarily, I'm not saying you, it's these guys breaking into these freight cars in the rail yard. And so it could be one of these wrong place, wrong time, or frankly, right place, because you live there, but wrong time. So there's not another step you need to do in terms of interacting with the state, but I will ask Ms. Cabrera to prioritize having a sit down with you so you can see the discovery, help her. Like, that's not, that one they say that's me, that's not me. Back then, my hair was down to my shoulders or whatever. And look, that guy's got close cropped hair. So stay strong on it. We're not going to bring you back here needlessly. Next time will be to either, great, you're going to have your trial. You don't have to prove anything. The state has to prove your guilt, or something has been worked out, whether that means a dismissal or diversion or who knows what. I don't get in the middle of the negotiations. I just approve them if I think they make sense. Okay? I appreciate your patience. You should go. All right, that was the calendar. Did any of our folks, Mr. Cook, did you make it? He's here, and I saw his lawyer. She was here briefly. Ms. Rockwell's around. She did her usual and moved on. Mr. Matthews, you are here. Good morning.
Good morning, Laura. How are you today, sir?
I'm well. Good to see you. Tell me your announcement on Mr. Roberts' case.
Yes, a little communication with maybe yesterday evening. I need to talk with her about the case.
Okay.
See where we are.
Okay, well, just so you and Mr. Roberts know, we're on a trial calendar. That's where we are. And Monday will be trial day. Today is not trial day. So you and Ms. Davis should talk. We've got until 11:30, so 2 hours this morning, and then 1 o'clock onward to make stuff happen.
Thank you.
You bet. Let me see. Mr. Johnson was here. Anthony Smith, did you make it? Okay, but Anthony Smith will be a bench warrant. Oh, he's incarcerated. Who just said that? Are you Ms. Fletcher? Hey, Ms. Fletcher. So Mr. Smith's in custody. Do you know where? Okay. You just know he's locked up?
Yes, I spoke with one, she called last night and she knew he had court this morning. And
she knows he's locked, where he's locked up. Okay. Okay. In custody. Got it. Well, that would explain why he's not here. And you are Ms. Fletcher. Mr. Dobbs is going to chat with you real briefly. He may not look like Ms. Wood, but he is Ms. Wood's law partner, and he's going to talk to you a little bit about the case, and we'll figure out. You've preserved your final plea rights, so if today is a day we're working your case out, you have the ability to say no thank you if I do something that's not what you were looking for. And I'm not saying you have to work your case out. If you don't work your case out, trial is next week and you need to be available all of next week. So because trial doesn't take just 5 minutes. And so you'll need to be here for jury selection, for the state's presentation of evidence, if you're going to testify, all that. But I'm going to ask Mr. Dobbs to talk with you because I've gone through the calendar once now. We're just catching up on who came in a little late. You and Mr. Dobbs will confer. He's going to let you know what the state's thinking about doing in the case. And he might do a little shuttle diplomacy with the prosecutor. And then you guys will let me know, you know what, we've worked something out, or we'll be here on Monday for the trial. Okay? All right. Mr. Stafford is here. Ms. Mann, did Ms. Mann make it? Did you have a chance, Mr. Dobbs? I know you've been sitting here. Did you have a chance to reach out to Ms. Mann?
I would talk to her. I have not yet.
Okay.
She has reached out to us and is on the way.
Okay.
She called me.
All right. So this is different from Mr. Smith, where we haven't had contact, but he's in jail. Ms. Mann is en route. Okay. And Ms. Fletcher is here. How about Crystal Alexander? All right.
I'm gonna reach out.
Okay. And we dealt with Mr. Johnson. That's it. Anyone here who thought they had a case on the trial calendar and didn't have it called? No? Okay.
We have another calendar.
We do. And we have Mr. Ambles and Mr. Williams, and we're going to turn to that. I just want to make sure if we didn't have anyone else on the trial calendar. All right. Did you, Ms. Fagan, have a chance to, I saw you go back there. I don't know if you're back there for 6 minutes or Has he seen the video now?
We handled one, I would request if he could come out just to make that announcement again about that.
Sure.
He could just be present.
Great. All right. If we could bring Mr. Tewitt to the door, please. And then we'll deal with, is Mr. Ambles here?
He's on the elevator.
Okay. And Mr. Williams is on the screen. So I'd like to do that because we've got GDC holding him.
And Judge, I'll be handling the Ambles matter on behalf of Ms. Nix. I believe she may still be in trial.
Okay. What are you doing? Oh. Tell Colonel it's all good.
He's here, Judge.
He said, he announced here you had stepped out. So everyone's here. Hey, Mr. Tewitt.
Hey.
Good morning.
Come on, sir.
It's been a minute since I've seen you. Your case should be first out on Monday. Ms. Fagan has announced ready, which I expected. I know there was one video that she was hoping to share with you, but she is going to have clothes brought over here either today or tomorrow, so you will not be dressed like that for trial. But my hope and expectation is that Monday morning we will pick a jury in your case at long last. You will be brought over either way. The world is a crazy place. There may be some reason why we don't go forward with your case. But you will be on the list of people brought over Monday morning, and you should know that that's for purposes of actually doing the trial. Today's the trial calendar. We figure out who's still standing, who's working their case out. You've made it clear through counsel, first Mr. Melnick and now Ms. Fagan, that you wanted a trial. It's just taken a long time to get there. But my goal is to have Monday be the day that we start that trial. And Ms. Fagan's good to go. We just need to get a prosecutor sitting at that table. Okay?
Yes, sir.
Any questions?
No, sir.
All right, Ms. Fagan, that video, he did see it, and so we're good, or you?
That we're having issues, so I'm hopeful that whoever does show up Monday could help me with some technical.
Okay, but you're okay if just during a break on Monday, that's when you shared. It's not something that without Mr. Tewitt telling you what it means, you're at a loss as to a defense.
All right.
Okay, good. See you Monday.
All right, thank you, sir.
And now, Your Honor, that concludes my business, right? Excuse me.
Yes, ma'am.
Thank you.
Ms. Rios and Ms. Davis, are you? Hold on one sec, Mr. Dobbs. Are you two, we're just gonna knock out the Williams matter and then I'll go away so people can do some pre-trying. Are you ready to do the Williams matter?
Oh, yeah.
Okay, let's do that. All right, Mr. Williams, can you hear us?
Yes, ma'am. Yes, sir.
Okay, great. So my understanding, Ms. Rios, is, oh, I meant to pull this up in Odyssey. There he is. Oops. In October of last year, well, let's make sure we get all this on the record just in case. Good morning, Ms. Rivers.
Good morning, Judge. Can you hear me?
You ready for some takedown?
Yes, I'm ready. Good
Great.
morning.
Good morning. This is 18 SC 160625, State versus Jamarco Williams. And Mr. Williams's attorney, Ms. Rios, has filed a motion to modify his sentence in that case. And what happened, I believe, is that in October of last year, I revoked a year of Mr. Williams's probation because he'd been arrested on some new charges. And after the service of that year, probation would be terminated. So the thinking was you serve the time and then you're all done. Life is sometimes more complicated. And this was a case from Judge LaGrua. I'm not quite sure why I was doing the revocation, but I did. And it was a sentence that Judge LaGrua imposed that had one of these, I think the term that was eventually used was a backloaded sentence. So it was 7 years probation followed by 3 years of prison. But if the 7 years went well, then there wouldn't be the prison. And getting revoked for a year is from one perspective, probation not going well. And so I guess DCS has determined now there are 3 years to serve beyond that 1 year of the revocation.
Yes, sir.
Okay. Mr. Williams, what have you been told and by whom about the 3 years?
I wasn't told anything. I had a release date for September the 1st. And once I pleaded guilty to my possession of cocaine, they said that my time wouldn't change. But once I did change it, once I did plead guilty on August 11th of this year, my time changed from 9/1/25 to 3/11/28. I didn't know anything about it.
Okay.
I remember the case from Judge LaGrua, but I didn't. It was a case that she sent me to a program, a 9-month program for my probation. I completed it, turned in my paper of completion. Then I guess my probation started for the possession of marijuana. But
okay,
I'm oblivious to it. I really don't know.
All right. I'm just looking at your other cases. Oh, so the other cases were with me, which is why I handled the LaGrua revocation. Okay. So what is your proposal, Ms. Rios?
That we amend the sentence just for it to be those 7 years and not the backloaded 3 years, since it seems like there was maybe some miscommunication. Those sentences are confusing if you didn't understand it. I know your intention was for him to do a year of probation. It seemed like that would have been, because that would have been, would have came up earlier. I don't know why this particular situation triggered it. I know speaking with his fiance, his mom has had another stroke. She's back in the hospital and he wants to be out to care for her, and his understanding or his thought process was that, okay, I'll be in for a year, but then I'll be out. And so we're actually requesting that 3-year confinement be amended off that sentence.
Not that he'd not do the year, he's done the year, but now sees that, the 3 years sprung up from the older case with Judge LaGrua. Okay. Ms. Davis, what are your thoughts about this situation?
Judge, according to my notes, it appears since Mr. Williams entered that plea in that 18 SC case, he picked up 4 different cases post that sentence. That to me doesn't seem like being compliant with probation. He had a case 21 SC 177988. He pleaded that, I believe, just a couple of months after entering a plea in the case. He picked up 23 SC 188007, 23 SC 190771, and 25 SC 001556. So I would posit that the 3 years was warranted.
The 25 SC case, is that still open? That one I don't have on here.
That was closed. It looks like it was pled to on August 18, 2025, so just a month ago.
25 SC. Can you say the number again, please?
001556.
All right, with Judge Richardson. Let me see what happened there. Okay. Ms. Simpson, it looks like Mr. Williams is going to have lots of probation, whether he's doing more time or not. This most recent case with Judge Richardson looks like it left him with 9 years probation. Okay.
And you show that he's still currently serving convictions.
On the Judge Richardson case. Yeah, no, he should be. I didn't see otherwise. Okay. All right, Ms. Rios, anything else on behalf of Mr. Williams?
Whatever he would like to say something, it looks like.
Okay, yes, Mr. Williams.
Mr. McBurney, I didn't know that when I was told that once I pled guilty to my Judge Richardson's case that it wouldn't change my release date. And the whole time I've been in prison, my release date has been September 1st, 2025. I don't know how this LaGrua's case popped up or triggered whatever, but I was told that my release date wouldn't change, and it did change. And the whole time I've been locked up, I haven't heard Judge LaGrua's name at all until August, a month before I'm supposed to be released. I haven't heard Judge LaGrua's name at all. So I was, expecting to get out to do better and go on with my life. So I'm just asking for sympathy.
Well, you certainly have my sympathy. I understand what you're requesting, and I'm sorry to hear that your mother continues to struggle. That's not a good thing. And I can understand why you want to be there. What I'm going to do, Mr. Williams, is take this motion under advisement. I've heard from your lawyer, and she's argued persuasively why I should modify the sentence. I've heard from the prosecutor, who's brought to my attention that your time on probation in the Judge LaGrua case hasn't been necessarily one where you did a great job of staying out of trouble. And so I need to balance those two things, and also take a look at that. You actually had 2 cases from Judge LaGrua. One's even older, but I need to look at those, and then I will enter an order that either grants the motion and I'll modify the sentence, or denies the motion because I find that the sentence you entered into, that you received, you had counsel at the time, and that you were aware of the plea that you had with Judge LaGrua and the possible consequences. I can't decide that right here, sitting on the bench. So I'll need to look at the docket, and then I'll enter an order. That'll go to Ms. Rios, and she'll be able to get that to you, okay?
Yes, sir.
Any other questions, Mr. Williams?
I have one more comment. So on the 10-year sentence backloaded, it's consecutive, so that means there's another sentence after this, a 10 for the 10 due 2. It's 2 consecutive backloaded sentences.
So it could be, I see a 12 SC sentence in there, and then there may be a 19 as well.
Is running consecutive to the cases.
Okay, can I have that number also? 19 SC.
165370.
370, okay, and we've,
6-year probated sentence.
but it's just probation?
Yes, Judge.
Okay, good, there's nothing backloaded that could explode on that one.
We made that one straight probation.
Okay, 115460. All right, I've got some homework to do, Mr. Williams, and I'll do that, and then I'll get an order in, and Ms. Rios will let you know, okay?
Yes, sir. Thank you.
Anything else, Ms. Rios? Ms. Davis? All right, thank you, everyone, and thank you, Department of Corrections, for making Mr. Williams available.
Yes, sir, you're welcome.
All right, I would like to speak briefly with Mr. Furlong. And I think, Ms. Davis, are you handling the Chastner matter?
Yes.
So we'll just go to the jury room, talk real briefly about that, and then I know lots of lawyers need to talk with these prosecutors, so I'll get out of the way and come back in to nudge you all in a little bit to see what we're doing, okay? And I guess you guys are gonna figure out if people are showing up.
I'll be ready to get back on the 2 pleas.
Mr. Jordan and Ms. Britton, okay? Did Ms. Mann make it yet? Ms. Mann is here, great. All right, Mr. Dobbs, if you'll talk with her. And how about Crystal Alexander? Still no, okay, all right. Oh, he was here. He was here when I called it. He was here and said you were on your way. He covered for you.
Thank you.
You bet.
Oh,
Yes.
yeah. It was. Judge, I believe Mr. Wells is here, maybe announcement so he can know that case was dismissed.
He is outside in the hallway, getting in, otherwise I could just relay.
Oh, yeah, have him come on in and I'll tell him.
I'll get it.
Thanks. Hey, Mr. Wells, how you doing? Just want to let you know the state was able to track down the death certificate. And as a result of that, they dismissed the case against you, okay? So you do not need to come back to court. I've already signed the order. Ms. Wood, when she's back in town, can get you a copy of it. If that's something you want, you may want just to keep it so you can show someone, hey, no, those charges were dropped, okay? But you're good to go for now. Any questions? All right, take care. Yeah, Ms. Mann, she told me she's here. We're good. So I think it's just Ms. Alexander and then Mr. Smith, but he's supposedly locked up. Okay. Mr. Furlong, if you go to the jury room with Ms. Davis, please.
Sound. Yeah.
Okay, so I mean, I understand that she wants to get something off her mind, so he said, yeah, well, I mean, Sam, the lady, he was not staying, but they're on the outside, right? Okay, right.
She drops the record, that's right, it's so sure, but judge.
I am sorry, hey, I'm not doing this on that case, right here, that's why we indicted. This is not, this is not, read the facts of the case, that's why we indicted. I'm never asked for money, she picked herself with an extension cord. And whoever provided the case did not, fully review all facts. So I knew that I'm fine with going to trial, but you as whoever representing her, you are entitled to have your full benefits. You are entitled to have it, because none of that was provided to you. And I thought we were going to be able to provide it. What I gave her was a gift. And the child had proposed a lady, also on building metaphysics. And it's like another small woman. I think he's like in the back or something. He is instead. He been a problem. And the fact that she didn't take the deal, her final plea makes no sense, you know, it's like, the only thing I said is like, you have to do that. And like, the training, whatever, I'm not the one who's saying this is on. And I haven't even gotten, I requested her retire the VHS one. So I'm waiting on that. And she don't understand is they closed her case now. They felt she didn't do what they want. They closed her case because they closed her case when you don't have any other outstanding issues with that particular child. That's why they closed the case. So her whole mindset, there's in the classes for the child is good. So she has, they don't move some time, and then she also has wire marks on all of her, when she broke it. So maybe it's not your case, it's not. Well, and so if she decides she want to go to trial, like, without, y'all gonna have to stay on the record that you're gonna stay in, you're not giving the full records and everything, and you decide to proceed. I'm not gonna say that. No, I'm just saying, but whoever does.
Yeah, we have to wait.
Yeah, because if she's not gonna take the deal, I'm gonna get all the records and make sure that everything, yeah.
So this is what you've seen, right?
Oh, that's not the only page. Let me, I'll show you. Yeah, so the DHS records speak about before like apparently it's a case against her. So things that I provided to you all is the 911 call on care. There's a forensic care and we need to have home for that to the certified medical records. They do other surroundings. From the child who's you also have records, so those are records from Will Steinbeck. We have records from Children's Hospital.
If I speak to the board that, we're still waiting on certain, evidence, what is he gonna say? We'll put it on the calendar, and you can have a continuance from that based on, what's he gonna say?
Our clients and the issues that were raised. So, we're ready for this to do. We need to review the forensic interview, we have DHS records, plus all of it needs to be, I requested.
And then you make on the calendar. It's all in the calendar.
Yeah, you guys did all that on the accounts.
Okay, listen, I see, okay, that's probably it.
Okay.
So we just see that.
Right, okay.
Is Rashida Davis in court?
Yeah, she went to the back, Mr. Kane.
Okay. Is there a case manager? Guess not.
No, I'm here, Mr. Kane. What can I help you
Oh,
with?
good morning. I'm running late. I'm here on Anthony Smith, and he's in jail in Clayton County.
Okay. Judge will be back on the bench in just a minute, but I'll make a note of it.
Okay. And
Clayton County?
yes, ma'am. Yes, ma'am. Thank you.
And Ms. Nelson, this is Kerry Johnson. I'm here as well.
Okay, I'll let the judge know. Thank you for joining the call.
Thank you. Yes, ma'am.
Fletcher. Good to chat, or. Look out there to do.
You don't have Stafford, do you? That's Stafford, is that Davis? Okay.
I think Davis. What kind of cases? Not Chuck.
It's not, no, it's not what you know. Okay, yeah, so the only one I have with you is the one we just talked about. Okay. Thank you.
Okay, thank you.
No, I think that, just in my office, I feel like somebody breathe.
You like to work here?
Hmm.
You like it here?
Oh, well, yeah, just one kind of like this.
You thought we go back to non-company.
Huh?
Thought we go back to non-company.
Why? Sure, why? What's the matter? The cane attorneys.
Oh, you don't need to fix this, say, I'll be on TV.
Oh, no thanks.
No day.
You were playing with me?
No.
I'm sorry.
One program is diverted. So they say, yeah, I don't know. I mean, that's why I never did.
Multiple. And I don't even have the full list. Just I'm like, yeah, let's go to trial in this case. But in fact, I'm fixing to go to DV and I'm gonna ask them. They can put this. I'm not sure this is just for them to make the findings that they did. And I didn't even look at the full list. What are you
No, a minute. The monitoring the neck after that.
I really had.
Because she was now, but apparently her cause.
That was a bad. That was a bad. But that game was not, that game was.
So, let's go. It was open.
They got that. We had it.
No, it's not. I know they were. It was like,
We were. We have.
Time in the history.
That, which that's been. We have. Okay. With you have people. We don't have in. But you're because of the type of hair, right? And.
All the money was on the deed.
Okay, I will wait for that.
All the money was on the deed.
Beards and.
Because that's what we have, that's what it's really, it's something I know it. We're not going to figure it.
That's all.
Yeah.
Just like this.
And nobody takes it seriously anymore.
Hey,
No, they don't. Keep it on paper. Seriously, now I'm ready.
They probably more scared of people.
Exactly.
They still sound
He came on the line, so I'm sure that was all the time. He told me, we're not joining. I ain't doing it. I ain't doing
That's all. They really like our
Can't see bad too.
Yes, they are. They ain't what they think to be.
It's Sunday night. It's Sunday night. Oh.
Yeah.
I was my man, the Jets.
Oh, no, man. I want to see that game. I want to see that game.
Council Patrick was playing. And he's one of those three. She should come back and show them.
I'm next. I'm next. I'm getting ready.
I wish I was my other friends. That was Sunday games. Oh, man. Oh, that's nice. Between the kicks and the upset.
You put 10 of them down.
I call Sunday upset Sunday because it's over. I wasn't expecting this. It was blown out my little hair.
The cults of the city.
They really want everything off of last minute. Also, they in the customer. Yeah. They want to last minute score. But they were literally, they were down by 3.
Typically going to the home. They want to grow that and that just being stayed in the
They got, a whole one of them?
Or ABC, ABC. The big thing is. Jordan, I got ABC. Everybody knows somebody, so they actually kind of home. Lower price.
Yeah.
Yeah.
I'm telling you. I can't stay.
I'm ready.
I am not. And this text too, so I can make sure.
Yeah,
Give me some, I'll do that, I'll sift through. Right, I'll sift through for you. And sorry, one question.
That was Manny.
Yeah,
but that's, I think it's nice.
There's that more a lot of.
Yeah, see, now, this is it.
And see, now it's. Yeah. I saw that out there, yeah, they
Stafford. Somebody what she exactly wrote on here, she wrote, she said there's a three of discovery.
Oh, yeah, I don't know.
That's what I got, so let me look at your, I'm assuming you have a certificate in there. What's the big Friday? Let's do this. Why am I hanging out?
But listen, I watched those videos. I ain't remember getting better. Yeah, that's all I'm doing. All you got to do is when you want to do it. It's really good.
Yeah. So what was served, on the initial discovery in May from Jasmine Delagar was, documents 5 and audio 1, so this is video missing in reports, so. Maybe. Yes.
And
Those documents, I don't know what documents.
Yeah, I have since added a ring camera.
But
But
so I'm gonna ask you to stay on.
it's not.
I'll watch it.
Right, so, okay, so that's what's up with that.
That's why I said.
Especially if we don't know that she is.
And then, well, yeah, I'll let you do
Do you
that.
wanna, is the easiest way, has partner access copy the case download? There we go.
Download link's probably the worst way.
That's all I have.
Right.
No, we always do like this. It's a different.
And those tax stories.
It's different.
Okay.
When you get a chance, and then after that, I wanna talk about.
Hold on, see, I can't do it this way, that's why.
Okay, then send me this, as long as I can, I can get it out.
If you don't, this one's gonna be.
That's why I said that and the text.
Which is why he does. That's why.
How, what was you doing the text?
Oh, man, Jackson.
Oh,
What is a lot,
yeah,
order.
so you did housing too.
I didn't watch this, I did that stuff, the basement court. I feel like I was.
That's it. Yeah. I sent you that, find her email.
Oh, yeah, I was surprised.
Baby.
I've always tried.
I was here.
Johnson.
Oh, yeah.
So I looked at it, so he hasn't officially received his official salary, he paid him $100, and $100 deposit, I looked at text, Johnson's phone with the Gary representative, on next to
It's like, it's
understanding that he is going to go. So, I would guess it's,
This one, I said,
immediately on the consolidated for official census.
yeah, so that way. It's like.
Standard is. And if there is no further evidence that indicates.
Right, according to Lacey, it's a ton. Right.
got this.
He just turned 41.
Oh no, but you got drugs. See, y'all always do that. I think it's pretty populated this way. I'm gonna click this. Okay. VHTC, so you know.
What's on there?
It's high, oh, I think it's highlighted red.
Yeah.
No,
but she put, whenever you transfer it, whenever you transfer it, they can use the same way. Cause they really don't have medical mechanics.
But she's been accepted.
Yeah, I guess, yeah. So that's what they told us. Let her do, that's what you know, she said, we're going to the credit for it, and then they're gonna transfer the bills for it.
It's weird. Well, she's not gonna have to do it.
Huh? She goes to behavioral health courses. There's money on
They're doing this,
Oh,
yeah.
yeah. There's money on her medical, which,
Oh, sorry.
yes,
Oh, and the county, yes. He basically said that they have the ability to teach CICs for years. So they didn't get, they're getting this college. So I think it's a matter of letting the sellers know that everybody's also doing that. So now they got a system where, yeah, he got the GCICs, but yeah, I'll show you. Yeah, post it. Girl, me too, but I can only do one and I never do anything off it, so it's like pointless. I can write it in my dry erase board, so it's bothering me. It doesn't bother me enough on my computer.
It's kind of like when I'll like do something like when I have like, you know, need it, and then like I'll just whatever, and then I'll go hunting down. Like I use this list to kind of.
Gordon, this doesn't work, FYI. It's off, you turned it on, it came off.
It went back on again?
It went back off.
You keep kicking it up.
That's like, you know, like I'm not too for the video feed, it's just there's no.
I'm saying, did it like the camera and stuff was on?
No, it was just like.
You gotta add it.
So you're doing close today.
Yes.
But we got things supporting that.
Oh, really?
I heard Jones. Okay. He funny.
Yeah, he is. That's my neighbor.
He they said the expert said that she can't identify that gun in his hand. So she don't know if it was the gun that fired or not. But it wasn't
coming on.
I don't think it was his gun. It was the other two that took the plea. Two took these and he did.
But they have maybe they're supposed to.
I guess they trying to give him a party to a crime.
Yeah,
Man, see the court come to order. We're trying to get him a party to a crime. Yeah, the buzz.
Henry County. I had heard Clayton.
Why do we call it like that?
Henry County. All right.
Our phones should be put away.
To do something about his bond here. Okay. Attorney Johnson, can you turn on your camera and mic, please?
Yes, Sean, I'm here. Let me park. I took off. Hold on 1 second here. I apologize, young.
That's okay. Well, while you're parking, Mr. Kane, let's pivot to you, Mr. Oh, you are parked now?
I am.
Okay, then we'll get to Mr. Kane. I just need an update from you on where we are with this evaluation of your client.
It is in process. I don't know the turnaround time. I actually spoke with, I can think of her name, Tiffany someone. Well, not spoke with, we communicated yesterday, and Tiffany Williams is her name. She said that, thank you for sending the police report. Mr. Wright is now in line on our list awaiting scheduling. So, that's it. That's all that I have at this point.
And where is she from, Ms. Williams?
She is from the, hold on one second. She is from the Emory School of Medicine, Psychiatry and Law Service.
Okay, that's the exact queue Mr. Wright needs to be in. I think there was a little bit of information that they were looking for that I believe the state has provided. Okay, so we're in the queue for this eval. We need to get those results. You remain ready if the results indicate we can go forward?
Yes.
Okay.
Correct.
All right. Well, we obviously won't get those during the course of this calendar, so I will bump this to the next available calendar.
Okay. And Yana, when I say remain ready, I have been in communications with 88 Charles, and we are actually still negotiating a resolution, and the outcome of this is going to determine that as well. At least as far as my client's concerned.
Got it. No, obviously, if he's not able to go forward or it shows he doesn't have criminal responsibility at the time, we've got a whole different landscape. But assuming the results are he could tell right from wrong at the time of the incident, which doesn't mean he did anything, but he could tell right from wrong, and he's competent to go forward, then you and Ms. Charles, and it's probably going to be Ms. Willingham after today, but that's a close colleague of Ms. Charles, are free to sort something out. You know, if you sort something out, we don't need to wait until the trial calendar call to do that. But I will move Mr. Wright's case to the next available trial calendar, and we'll see what happens.
You know, for some reason, I didn't realize we had court today. I apologize. I did not pencil it in on my schedule for some reason on my calendar.
That's okay. I knew we weren't going to be able to go forward. I just needed to get an update from you and the prosecutor about where you thought we were in the evaluation process.
Understood.
All right. Thank you, sir. You're good to go.
Thank you, Yana. Have a great day.
Mr. Kane, good morning.
Yes, sir. Good morning to you. How are you?
I'm hanging in there. Yourself?
I'm about the same. I'm here on Anthony Smith, and regrettably, he's not here. He's incarcerated in Clayton County.
So, yes, but I'm hearing he's actually in Henry County. Either way, he's not here, and
Well, that could be my mistake. That was a girlfriend said he was in jail in Clayton, but it could be Henry.
Okay. Either way, he's in custody. No one is doubting that. That'll have a ripple effect for him. Obviously, we can't move forward with anything today, whether it was going to be a plea or a let's go to trial on Monday. But we will lock down where he is, see what that does here. And when we can sort that out, I'll have Ms. Nelson reach out to you so we can figure out next steps.
So thank you. So I have pre-tried the case with Ms. Rashida Davis. We came to an agreement on a plea, and if we can get him released from Henry County, we can schedule him before Your Honor for dispositive plea.
Excellent. So we can see if he's going to be in Henry County for a while, if he could appear virtually, or we could do a production order. If he is just going to be a quick visit to Henry County, then you and he can walk in through the doors of the courtroom. We'll figure it out.
All right. Very good, sir.
All right. We'll be in touch. Thank you, Mr. Kane.
Thank you. Good day to you.
Same. All right. Any other announcements? Because we have some pleas that I'd like to at least get one or two of them in before we break. Mr. Dobbs.
Yes, Judge. So on Mr. Stafford, Well, we just stand up, please.
There he is. Hey, Mr. Stafford.
So Judge, per Miss Wood, there is a bunch of discovery missing on this case. So at this point, I've discussed that with Ms. Davis. She's made a note to send us what we don't have. I understand this is already on a trial calendar. I'm not sure how the court usually proceeds here, but we are missing some discoverable evidence plus per Ms. Wood, and I've discussed that with Ms. Davis.
What's an example of something you don't have?
So, in my certificate of discovery, what I see is documents, parentheses 5, audio, parentheses 1. The term that Ms. Wood used was a ton of discovery is missing, so what I would take that, I haven't seen the documents, but I would guess that there is footage missing, body worn camera footage, perhaps surveillance camera footage,
Burglary.
Okay, maybe there are other forensic things missing that would be used in a burglary case, so.
Okay, you don't know is the answer.
I don't.
All right, Ms. Davis, what does discovery consist of in this case? So what could be missing if something's missing?
As probably the body worn camera, I know I did recently receive a ring camera footage. It is something I requested from my investigator. And
Right, but you mentioned that, and that's not a ton of discovery. Certainly the defense gets it, but one, you might not have known the ring camera footage existed, so that can't be something Ms. Wood was saying, where's the ring camera footage that the state doesn't even have?
Yes, I mean, yes.
So you're thinking maybe for whatever reason, the body cam, is there body cam in the case?
I'm not sure. I did request it from our investigator.
Okay.
I'm not sure. I don't believe it's in the theevidence.com.
Okay. I guess Ms. Wood's gonna have to tell us that when she gets back. All right. Ms. Rios, do you have good contact information for Mr. Stafford?
Yes, I believe we do on, yeah.
Okay. All right. Mr. Stafford, you're good to go right now. You may still need to come in here next week. I need Ms. Wood to explain what it is she thinks she doesn't have. If there is a ton, she's entitled to it and you are, and we can't go forward. But if a ton actually meant I didn't have one page from it, we could go forward and we should go forward. This is an old case. I know the indictment is new, but the alleged incident is from 23. So it's time to be done with it. All right. Any questions? All right. You can take off. That's it for Mr. Dobbs. All right. Any other, oh, he's back. Any other announcements, Mr. Dobbs, for the cases you're graciously helping out with?
Miss Megan?
Yeah. Is there a new indictment? I got there's some email traffic about a new indictment.
Yes, Your Honor. The state had to re-indict the case because the third count did not reflect the weapon used against the child.
Okay. But setting that aside, if Ms. Mann wanted to work things out, that she could work it out to the old indictment. What were you going to say about Ms. Mann?
So, similar to my last announcement, per my conversation with Ms. Clark, there are some documents, namely some defects documents and some other evidence that has not been served at this time that Ms. Clark is going to get to Ms. Wood. We have a trial.
We're on trial. So, Your Honor, in full candor to the court, I believe, based on looking at the charges and the fact that the child had been returned, I believe that we would be able to resolve this case short of trial.
I think we talked about, I'm going to play back what I'm remembering. With Ms. Rios present, we talked about this case. And was this one where you had offered family first?
Family first, 10 years probation, and it was actually a behavioral incentive date after 4 years.
Okay. And some of the back and forth had been, well, but there was an independent inquiry and the child or children were returned, or there was a finding, not in court here, that maybe there aren't reasons to be concerned. And you're taking that into consideration as well. But there also were more than minor injuries to the child.
Yes, Your Honor. There was more than one broken bone. And
since I was told by Ms. Wood that her client was wanting a trial, then of course, I looked at it from that perspective, and I know that I've sent this to Mr. Dobbs and Ms. Wood in an email, but there's a forensic interview that's not been turned over.
Oh,
Certified medical records from 2 different hospitals, from Wellstar and Showa. There's also the body-worn camera footage that is on there from Detective Allen, who was the lead detective. That video that's on there is actually from another defendant from another case. And so the body-worn camera footage, I put the request in, I think at the end of last week. But yeah.
to avoid any disappointment or frustration, you've described an offer that in my mind doesn't really align with the seriousness of what you're describing. Is there an expiration date to your offer so that we're not together again and you've decided, it's fine, let's go to trial, and it's not 10 years probation with a behavioral incentive date and complete families first?
You're right, yes. So the only reason why, so the offer expires when you excuse me today from your court.
Okay.
Because based on my review of the case, that offer and of the evidence, I believe is substantially lower than what I would have probably sought, and I'm prepared to try the case.
Okay, got it. Mr. Dobbs, it sounds like this is one that, well, you've spoken with Ms. Mann. What does she want to do?
Well, Judge, I mean, at this time, now that I've been informed that there's evidence we don't have, I don't know how to advise Ms. Mann. I don't know that Ms. Wood has been able to properly advise Ms. Mann. So for that reason, I mean, we need to get this evidence before I know how to proceed, and before Ms. Wood will know how to proceed.
Okay, I get that, and it sounds like she may not be characterizing it as a ton of evidence, but it's something that Ms. Wood, it's a different case, I understand, but that Ms. Wood and Ms. Mann would want to go over together to say, whoa, look at this.
Well, certainly.
Okay.
I was not, she didn't characterize any, she didn't tell me there was any missing evidence
In this.
For me, it was this morning in my conversations with the state that I learned that.
Okay, got it. Ms. Mann, do you have any questions about anything we discussed? Okay, then I will excuse you also, and we'll need to put this on the next available trial calendar, provided that gives Ms. Wood enough time to digest the evidence and to talk with you about it as well, okay? All right, we'll see you.
Those are all my announcements.
What about Ms. Fletcher?
I'm still working on that case.
Okay, good.
And it's okay, and I'm realizing now that that's actually not all of my announcements now, because Mr. Johnson.
Oh, did Crystal Alexander ever show up?
No, you should.
All right, bench warrant there. All right.
Excuse your honor.
Yes, ma'am.
Wait, who's handling William Campbell's?
Ms. Davis?
Okay, never mind. Yeah. Never mind.
All right, so Mr. Johnson and his 3 cases.
Yes, Rich. So, Mr. Johnson showed me text messages for his correspondence with the Next Level Boys Academy representative, who is, let me give you his name. That is Mr. Gary Davis. I see that Mr. Johnson has given them a deposit of $100. I see that he has planned to. They've discussed logistical things of when to show up, where, and do things. So I'm confident that Mr. Johnson has been, allowed into this program. He's waiting on an official acceptance letter from him. So I would ask that he remain on the consolidated calendar, which I think he's on.
He is.
In order to get all of this so that Ms. Wood can come to a global resolution on all of Mr. Johnson's matters.
Ms. Davis, is Ms. Wood hoping that that's a way the case would resolve, or you and she have had discussions where if Mr. Johnson takes these proactive steps that he's been taking, gets into this program, I'm sure there'll be other conditions as well, but is that even on your radar, or is that fanciful thinking because the state's view is that the recommendation is here rather than here?
Well, Judge, we weren't necessarily in alignment on what that plea was going to look like. I do think it would end up being non-negotiated, but it was going to be a part of the conditions that he has some sort of
affirmative actions to change the trajectory of his life.
Okay.
It seems like it was going in an interesting direction, but this is, while he has 3 cases on the calendar, these are his first sets of cases.
Are or not?
They are.
They are,
Yeah,
okay.
so this is no history. But yeah, it was my understanding that there would be a resolution, and she was working on this amongst some other items to present before the court, and then
Okay.
the judge decided we can't come to an agreement.
Got it. So this can stay on the consolidated calendar because Ms. Wood will be back, and then we'll see where it goes.
Absolutely, and so I would hope to speak with her once she returns, and then potentially coordinate with Ms. Nelson.
Right.
Maybe for the end of next week, but I just need to speak with her.
Sure, and we can do the plea. You don't need to wait for it to be that Monday in front of Judge Emerson if something lines up. Okay. All right, Mr. Johnson, you're gonna wanna stay in close contact with Ms. Wood. She's hard to reach right now, but she's gonna be back, and then this case will be a priority for her because it's not only on my calendar, I put it on we have a visiting judge, and we get to submit cases, and you had 3, so I thought we'd get that moving that way. So Ms. Wood's gonna wanna talk with you. Does she have your info?
Yes, sir.
And you have her info? Okay, any questions? All right, Mr. Dobbs, anything else in connection with Mr. Johnson?
No, Judge, and those are all of my announcements. I'm still pre-trying on this budget matter.
Got it. Okay. Can we do either Ms. Britton or Mr. Jordan now?
Yes.
You can pick.
This, who was here
Mr. Jordan.
first? Yes, Mr. Jordan.
Come on up, Mr. Jordan. And Ms. Davis, did you end up having a chance to speak with Ms. Rockwell or Mr. Matthews?
With Mr. Matthews.
Okay.
We have a resolution, Ms. Rockwell, I have not seen her this morning.
TBD, okay.
She has reached out to my manager, so I received some text.
Okay, she's not gonna disappear. I mean, permanently disappear. Okay. All right.
Oh, no, I think people on terms will look at it, just make sure it's missed. Okay, I need just like 2 minutes, so. It's on one of these, it's a year. I'm just curious. Okay, well, one of the cases that we did, I want to spend some days on the going down, so. Okay. I'm ready.
Let me know when you're ready, Ms. Davis. Great. Ms. Rivers, are you good to go?
Yes, I'm ready.
All right, we're handling positions 1 through 3. All involve Michael Jordan, who is here in court with his lawyer, Ms. Rios. Ms. Davis is here for the state. Good morning, Mr. Jordan.
Good morning, Judge.
Ms. Rios tells me you're ready to resolve your cases.
Yes, sir.
Okay, Ms. Davis will put you under oath and ask you a bunch of questions about your rights. Please let me know if you've got any questions of your own or if we reach a point where you're not following what we're talking about. Will you do that?
Yes, sir.
Okay, Ms. Davis?
Please raise your right hand. Do you swear or affirm the testimony you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes, ma'am.
Please put your hand down. Please state your true, correct, and legal name for the record.
Michael Jordan.
At this time, are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
42, 10th.
What high school did you attend?
Washington High.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses in indictment 20 SC 175168, burglary in the first degree, 2 counts, and possession of tools for the commission of a crime? And indictment 24 SC 003316, burglary in the first degree, possession of tools for the commission of a crime, and criminal trespass. And in indictment 25 SC 001534, burglary in the first degree. Do you understand that?
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding these indictments and any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of all the indictments and any and all defects therein for the purposes of this plea?
Yes.
Mr. Jordan, do you remember being arrested on these charges?
Yes.
Your Honor, the state's unaware of any outstanding warrants related to these matters. Attorney Rios, are you aware of any outstanding warrants related to these matters?
No.
Mr. Jordan, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
For burglary in the first degree, the minimum sentence is 1 year. The maximum is 20 years. For possession of tools for the commission of a crime, the minimum sentence is 1 year, maximum of 5 years. For the offense of criminal trespass, the maximum sentence is 12 months. Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes.
Do you understand that the court's not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence for each charge?
Yes.
Do you understand the court has the right, there are multiple charges to which you are pleading to today, and the court has the right to run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess a firearm while on probation?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation just like a conviction and a trial would? And that's true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'd be guilty of a felony which can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges and 12 months today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 20 SC 175168, burglary in the first degree, 2 counts, and possession of tools for the commission of a crime?
Guilty.
How do you plead in indictment 24 SC 003316, burglary in the first degree, possession of tools for the commission of a crime, and criminal trespass?
Guilty.
How do you plead in indictment 25 SC 001534, burglary in the first degree?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes the evidence would show at trial in indictment 20 SC 175168 that on January 17, 2020, officers with the Atlanta Police Department were dispatched to an alarm call at 2696 Santa Barbara Drive in Atlanta, Georgia, in Fulton County. The officers discovered the rear window of the location open and an air conditioning unit that appeared to be previously in the window was set on the ground. Officers also observed a fan, a VCR were on the ground underneath the window. Officers entered the property through the window but did not locate anyone inside. They made their way to a second alarm that was triggered in the area 2566 Santa Barbara Drive and noticed the back door was open and a window with a bent screen. There was pink insulation outside of the property as well. This was a vacant property. Officers then noticed the defendant, later identified as Michael Jordan, walking the roadway. He was wearing gloves, a backpack, had white powder on his clothes. Officers detained him as there was a report of suspicious person in the area. They located a set of rusty pliers, crowbar, and other tools on his person used to break in. They returned to the original location of the call and found some rusty tools that matched the same make and size of the tools that were on the defendant's person.
That was the case ending in 168?
Yes.
The indictment talks about addresses of Baker's Ferry Ridge rather than Santa Barbara. Are those near each other?
I believe they're on like a cross street.
Okay.
The indictment. But that is where they were able to identify the defendant and pick him up.
Okay.
And I can pull up the warrant and give you the address because, yes. Yes, correct. And I have the location of the actual incident was 266 Baker Ridge Drive, Atlanta,
Okay.
Georgia, in Fulton County.
Got it.
In indictment 24 SC 003316, this incident occurred on June 19, 2024. Officers responded to 917 Stonewall Drive in Atlanta, Georgia, in Fulton County for a report of two suspects breaking into a vacant home. The caller was the homeowner, Ms. Alicia Price, who reported that her neighbor spotted two individuals arrive at the home in a Chevy Trailblazer. Officers observed the vehicle running on the street. When they attempted to make contact with the individuals who were exiting the house, they immediately took flight and ran through the woods. Officers were able to capture the defendant, who was later identified as Michael Jordan. They performed a show up with one of the neighbors, and they positively identified the defendant as one of the individuals who exited the Trailblazer. He was Mirandized and spoke with the officers. He stated that he left his home for a jog. They did look at his location of where he lived. They confirmed that he said he lived at the address on his driver's license, which was 18 miles away. Officers observed in plain view of the vehicle 2 large cutting tools, a hammer, and multiple pliers. In indictment 25 SC 001534, we believe the evidence would show that on March 20th, 2021, officers with the Atlanta Police Department responded to 307 Spelman Street in Atlanta, Georgia, in Fulton County. They observed the defendant, later identified as Michael Jordan, exit the property that was under construction. He had on his person a camouflage mask, gloves, and a flashlight. Officers inspected the property and saw damage to the alarm system. Water heater and window was cut out. The defendant did not have permission to be on the property from the owner, which was Anthony Alamo. As the court is aware, these series of cases were for a defendant who had participated in accountability court and had been in that program for a while, but ultimately is resolving it today with the plea. Our offer to defense counsel was as follows. It is 10 years to serve 1 year, which the defendant has already done. I believe he served 370 days on one case, 40 days on another one of these cases, and 72 days on the third case, for a total of 482 days. We do want to acknowledge that and give him credit for that year of service, but we want him to serve an additional 10 weekends. And then for the sentence to be on probation, for him to complete an anti-theft course, a drug and alcohol evaluation and treatment if treatment is required. He's to have no contact with any of the victims. Those victim names are Sherry Ying and Barbara Ely, Alicia Price, and Antonio Alameo, and I will email them to your litigation manager. He's also to stay away from all incident locations, and I will submit that information as well.
All right.
And then, of course, for the one misdemeanor offense, it would just be 1 year to serve, which he's already done. He has one count of criminal trespass.
Right. That is on 316.
Correct.
Okay. All right. I've seen which one it's attached to. I'm lining up the time served. Thank you for your email. The year served was on the 20 SC. The little more than 2 months was on the 25 SC, and a little more than 1 month was on the 24 SC. Okay. Got it.
One last thing here, I'm sorry.
Yes, ma'am.
Also, a condition of his probation would be for him to complete and remain active in the STAND program.
Stand.
Yes.
All right. Okay. We don't have pretrial services here today. We do have, whoa, in person, what? Wow. How are you, sir? All right. Thank you for being here. What can you tell me about Mr. Jordan's criminal history?
24 arrest cycles. Last felony conviction was 2007, possession of cocaine. He had a 04 Dunbar season guilty. And a 2003 manufacturer controlled substance. That's it.
So 3 priors. Got it. Okay. And the last arrest? Not in front of you. Okay, that's all right. I was just curious. It has to have been 1 in 24 for the Stonewall Drive burglary, but I was just curious if there's anything more recent. Ms. Rios?
Yes, Your Honor.
Let me pause you for 1 second. Ms. Simpson, is Mr. Jordan, those cases are ancient. He's not on probation for anything now.
But I can answer your last question. This last arrest was June 19th, 2024.
Okay, that's our middle case here. All right, Ms. Rios.
Yes, Your Honor. Mr. Jordan is 42 years old. Right now, he's working for Compass Liberty Moving. He's been doing that for about 3 years. He has 2 children, ages 14 and 17. He has been admitted to the STAND program. I don't have a letter yet, but my social worker Ms. Ross sent me the email correspondence that they said he was accepted and they will be getting a letter over shortly. I think that is an appropriate program. I know he was doing drug court. That didn't work out too well, but this other.
It actually went real well for a while. And Mr. Jordan's going to remind me where things went off the rails, but he did well in drug court for a while and was a kind of community leader of sorts when he was in there. So it worked.
Probably do good in the STAND program, getting another shot. It seems like he hasn't been in trouble in a year. He hasn't picked up a new case. He's trying to turn his life around. He has 2 teenagers that he needs to be a good example for. So I think this is a good resolution to all 3 cases. So I ask that you accept the plea as negotiated.
Okay. Mr. Jordan, remind me, I may get this wrong because it's been a little while. One of your kids, boys or girls?
Girls.
And maybe at some point during drug court, they ended up, you had full responsibility for them? Or you've always had full?
One, Jessica.
Jessica, she moved in with you or something?
Yes.
Yeah, okay. Is she still with you?
No.
No, okay. Do you get to see her?
Yes.
Is she the 17-year-old or the 14-year-old?
14.
Okay. And is the 17-year-old local?
No, she's in Augusta.
Okay. But Jessica, you see her how often?
Every weekend.
Okay. And she doing all right?
Yes.
Where's she in school?
She go to Columbia.
Okay. All right. And how long have you been with the moving company?
3 years.
3 years. You were working there when you were in drug court?
Yes, I was working there on the weekend.
On the weekends, because you had a different
Yes.
gig during
With
the,
the CKS.
yeah, okay. And what happened with that job?
When I got incarcerated, they just let me go.
Okay, for the June arrest?
Yes.
Okay, all right. Anything you want to add?
I wanted to know about being in the program and doing the 10 weekends at the same time.
So I don't know enough about Stan. You worried that there'll be a conflict? Like they'll say, where are you on the weekends? Or what's your concern?
About getting back and forth from staying and not having a job. And well, I was trying to work on the weekends.
Okay.
But if y'all want weekends and the stand program, it's like the issue with money of getting to the program every day, which is in Covington Highway, Covington Road.
That's where Stand is?
Yes.
And is Stand, it's 5 days a week?
Yes. From 9 a.m. to 1 o'clock in the afternoon.
Oof, okay. That's a lot for how many weeks?
I'm not sure right now. I'm supposed to go in for the interview tomorrow.
Okay. An interview as whether they'll accept you or not, or an interview where they're just giving you more information?
An interview to be accepted in the program.
Okay.
Yeah, I'm already accepted in the program. It's just.
So what's the interview?
They need me down now because I haven't went down there physically.
Okay.
So I was doing a chest x-rays and all this, my physical and all that until it came back, and it came back yesterday. So I was accepted.
Okay, all the things you're describing, that medical stuff, that was required by Stand.
Yes.
You're not having chest issues.
No.
They just need to make sure you don't have tuberculosis or whatever.
Right, yes.
Okay, all right. But it's not residential. You'll get to go home each day.
Yes.
All right, and how are you gonna get there?
Vehicle, I got a car.
You have a car?
Yes.
Do you have a license?
Yes.
Valid license?
Yes.
Okay. So your concern is, heck, if I'm doing that, I gotta make some money, and that would be on the weekends.
It will be on the weekends.
Unless you're in custody on the weekends.
Right. Yes, sir.
So what's your proposal, other than trying to change the arrangements, which is a bad idea? Is it do the weekends later? What?
Not sure. I was just bringing it up to the courts.
Okay. I think you already said this. You don't know how long Stand goes, if it's a 2-month program or a 10-month program?
I don't know. I haven't got into the, actually haven't asked the question at the same program yet.
Got it. Okay. I think I have a solution. Anything else?
No.
All right. Well, Mr. Jordan, I've already told you, I'm sorry drug court didn't work out, but life is complicated. You had a lot of stressors in your life, and you did what you did. I do find there's a factual basis for your pleas in the 3 cases. A couple of them are super old, in January 2020, but the goal was to get through drug court. That case goes away, and you didn't get through drug court, so you need to resolve it. I also find that your pleas are knowing and voluntary. That means you've understood what we talked about, and no one's forcing you to enter these pleas. Do you agree with that?
Yes. But yesterday, it was just put on the table to me. I found out that the state was asking for the 10 weekends.
Okay.
So, yes.
Okay. I understand that, and you don't like it, but you like that more than maybe going to trial and the jury finds you guilty. And,
I'm with it. It just, I thought it was going to be either or.
Okay. Got it. I'm sentencing you pursuant to the Probation Options Management Act. Ms. Rios, can someone in my office sign the 3 indictments for you?
Yes, sir.
Ms. Davis?
Yes, Judge.
Mr. Jordan, can we electronically sign your name indicating your guilty pleas in the 3 cases?
Yes, sir.
Ms. Davis, one of the cases, the one ending in 316, has the criminal trespass charge because Mr. Jordan, that may have been the one where there was a second guy, but the burglars damaged Ms. Price's door. Are you seeking any restitution, or is that not how it's going to play out?
No, we're not seeking any restitution. It's my understanding that house, we did speak with the victim. It was already vacant. It had recently had like a house fire. So
Okay.
it was already damaged.
It was being worked on to rehabilitate it. Okay. All right. Mr. Jordan, in 20 SC 175168, your sentence on counts 1 and 2 are 10 years to serve 1 year with a balance probated, and count 3 is 1 year to serve. They all run concurrently with each other, and you'll get credit for the time you served in connection with that case. Special condition of probation number 1 is that you enter into and successfully complete the STAND program. Special condition number 2 is that you stay away from those residences on Baker's Ferry Ridge. Number 3 is that, does STAND include drug treatment? Did they talk to you about that?
I believe it was a drug treatment program.
It is. So I'm not going to require the drug and alcohol evaluation and treatment. I think you're getting that through STAND. STAND is often offered up as a, drug court's not going to work out or a person wasn't admitted, so they do STAND. You do need to take an anti-theft course. And if you don't complete STAND, either you quit or they toss you out, then you will need to do 15 weekends in jail following your termination from STAND. All right? So STAND goes well, you don't have weekends in jail. If you blow it, then you will have 15 consecutive weekends in jail.
Yes, sir.
Get it?
Yes.
All right. In 24 SC 003316, your sentence as to count 1 is 10 years to serve, well, I'm gonna make that 9 years to serve 1 month with a balance on probation. Count 2 is 1 year to serve 1 month with the balance on probation, and count 3 is 1 month to serve. That's the misdemeanor. They'll all be served concurrently. So that's 9 years to serve 1 month, balance probated. And the same special conditions, except it's stay away from Stonewall Drive. That's the address of Ms. Price's house. But otherwise, it's the STAND program, all that kind of stuff. And your final case, 25 SC 001534, it's just 1 count of burglary, and that is 9 years to serve 2 months with the balance on probation. And then the same set of special conditions, except it's stay away from Spellman Street. So there are certain streets you need to not be active on. Do you feel like you know what those streets are?
Yes, sir.
Do you live on any of those streets?
No, sir.
Okay. All right. The thrust of it is do well in the STAND program. If you don't, it's 15 weekends in jail. All those other conditions are things you need to take care of. Ms. Davis, anything else in connection with Mr. Jordan's cases?
No, Your Honor. I also just want to notate for the record, I think I may have filed a recidivist notice in these cases and obviously withdrawn that for this plea.
Okay. Let me check. You confirm that you did?
Yes.
Okay. The recidivist notice is withdrawn, and we'll move forward that way. Ms. Rios, anything else on behalf of Mr. Jordan?
No, Your Honor, thank you.
Mr. Jordan, what county do you live in now?
Fulton.
Fulton. All right. Ms. Simpson is going to give you reporting instructions. Do you know where the probation office is in Fulton?
Yes.
Great. Ms. Simpson?
Mr. Jordan,
30315.
so your reporting date is going to be September the 29th. That is this coming Monday. And you're going to report to the Atlanta office at 8 a.m. The address is 276 Memorial Drive, Atlanta, Georgia, 30303. And I'll give you everything documented.
Okay, good.
All right, good luck.
Thank you.
Mr. Matthews, good morning.
State and I had an opportunity to confirm, and we do have a negotiated resolution that we want to for some consideration.
Okay, this is with Mr. Roberts?
Yes.
Got it. Okay. And
I've been there before. Yeah. Sorry. It's on the 6th, right? And the date fixed on.
Hey.
Right.
Oh, yeah.
Hey, 2 copies.
Oh.
So, just somebody did just pass it at meetings.
Excellent. Can I keep this?
Yeah.
Okay.
I didn't know you wanted to ask the person.
It's not a big deal. Don't go research it.
Those just all felt.
That's everyone. Okay, excellent. Thank you. Thank you.
Talk fast and eat right. So that's why.
Got it. So I don't mean to interrupt you all, but if we're going to squeeze in one more plea before I have to go to this 11:30, we should start it. I don't know, Ms. Rios, that we would fit Ms. Britton in 16 minutes, but we might be. Is the Mr. Roberts plea complicated, or you will keep it simple? Let's bring Mr. Roberts up here then, please.
I told Ms. Grant you can go get lunch.
Sure. You can talk with her and let her know. We will do her first when we reconvene at 1. Mr. Cook, we will deal with your case once we rediscover Ms. Rockwell. She's in the building. She's usually in like 12 courts at once. And Ms. Fletcher, I could hear Mr. Dobbs trying to work your case out. So I'm gonna have him talk with you and but I gotta focus on, yes?
May I make one thing, Judge, and I'm sorry to cut in.
That's okay.
My client does have a flight at 12:45.
Oh, well, she shouldn't miss the flight.
May I inquire of this court, I'm sorry, I'm very sorry. May I inquire of this court and make a request?
Sure.
My client here, Judge, I understand that Your Honor is a very efficient judge who wants cases to move in a certain way. My client is starting dental assistant school next week, which would be the trial calendar. She's in school and she's got it next week. She has a flight today at 12:45.
Where are you flying to? For work or for something different? Okay, when do you come back?
I'm having Saturday, I'm having my caterer.
You're having what?
I'm having some my caterer, like decorator in the event.
Okay, but you're not going away for 10 years.
School next week, that's what he was saying.
Okay.
Yes, sir.
And so I have evidence that is extensive that Ms. Wood has, that I think either myself or Ms. Wood needs to sit down with Ms. Davis and go over with a fine-tooth comb, because it's not really reasonable for her to do it all by herself. So,
Okay.
Judge, I'm asking for my client to be reset beyond next week's trial calendar because of these circumstances. And I know that the court doesn't like this, and I'm sorry to ask, but I really feel like this is necessary, and this case should not even go to trial.
Okay, well, I'll say this, Ms. Fletcher should go catch her flight. And we'll work through next steps. Dental school is local?
Yes, sir, it's tomorrow.
Okay, got it. Ms. Wood will let you know what's happening next week, okay? All right. You bet. All right, let's focus on Mr. Roberts. Mr. Roberts, let me find your case here. 10, thank you. Here we go. You are 24 SC 000-534. You're represented by Mr. Matthews, who's here in court. Ms. Davis is the prosecutor. And you just sat through a plea, so you know how that works. And I'm seeing here you've taken a few pleas before. So we're going to do the same kind of thing. You'll be put under oath, answer questions, and we'll go from there, okay? Let me know, or your lawyer, if you've got questions of your own.
Yes, sir.
Thanks.
Mr. Roberts, please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name for the record.
Damn, Lawrence.
At this time, are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today? How old are you and how far have you gone in school?
62 years old, finished high school,
What high school did you attend?
Smith Valley.
Where is that?
Oh, Smith Valley, Hill Street.
Okay.
M.L. King Middle
Oh,
School.
Oh,
okay.
okay.
They tore down the
Yeah.
college five.
Oh, okay, understood. Thank you. Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offense in indictment 24 SC 000-534, possession of cocaine? And Judge, we are amending this from with intent to distribute because it was just a little bit over a gram. So it's just simple possession
Okay.
and possession of a firearm by a convicted felon.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges and remain silent, and then you would receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Attorney Matthews, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Roberts, do you remember being arrested on these charges?
Yes, ma'am.
Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Matthews, are you aware of any outstanding warrants related to this case?
I am not.
Mr. Roberts, has your attorney advised you of the minimum and maximum sentence for the charges to which you are pleading to today?
Yes, ma'am.
For simple possession of cocaine, it's 1 year to 8 years. For possession of a firearm by a convicted felon, 1 year to 10 years.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand the court's not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence?
Ma'am.
Do you understand do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes, ma'am.
Do you understand that while on probation, you're not allowed to possess a firearm?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'd be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And there's 9 of them, and then I'm gonna ask you, do you understand, okay? You're giving up the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 24 SC 00534, possession of cocaine and possession of a firearm by a convicted felon?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Ma'am.
Your Honor, the state believes the evidence would show at trial that on May 10, 2022, officers with the Atlanta Police Department, the Narcotics and Titans Unit were executing a search warrant at 12 Gould Street, Atlanta, Georgia, in Fulton County.
What street?
12 Gould?
Gould, okay.
Gould.
Got it.
Maybe mispronouncing it.
Nope.
The officers made contact with the resident and 3 people who exited the home. One of those individuals was Mr. Stanley Roberts, the defendant. Upon search of the home, the officer noticed in plain view what appeared to be suspected crack cocaine on the top dresser. The GBI would later confirm that it was cocaine in the amount of 1.475 grams. The K-9 unit swept the bedroom and alerted to a handgun. There was a .22 caliber also located in bedroom 1. Inside of bedroom 1 were documents and pill bottles with the defendant's name on them. No other narcotics were found inside the home. Mr. Roberts was Mirandized and agreed to speak with officers. He admitted to bedroom 1 being his room. Officers confirmed that Mr. Roberts obviously is a convicted felon and prohibited from owning or having in his possession firearms. The state is making a recommendation for the defendant for 5 years to serve 30 days. The defendant has already served that amount of time. He was revoked on 17 SC 151537 for this case. We're also for the balance of that service to be on probation, that the defendant complete a drug and alcohol evaluation and treatment if treatment is required. He does have his high school diploma, it's my understanding, so there will be no GED requirement. We also will be requesting that he forfeit a firearm and that he commit no further violations of the law and stay away from that incident location. The state filed a recidivist notice in July of 2024, and we will be withdrawing it for consideration of this plea.
Got it. And I have, Mr. Roberts, that you've got 21 arrest cycles, 1, 2, 3, 4 prior convictions, some of them from long ago, 90, 91, drug stuff. The most recent was 06.
Yes.
So you were either out of the business or not caught for a long time. Then this popped up. So something slipped. Mr. Matthews.
Yes, Sean, I'll be very brief. As the court has previously heard, Mr. Roberts is 62 years old. He is a graduate of high school. His brother, who has been present with him today and on most of the other prior occasions, is also present in the courtroom. Can you raise your hand? All right. It's Mr. Roberts as well. He does also have he did serve 37 days in custody, Your Honor, which the state has indicated as a result of a revocation. Your Honor, he has 2 character letters. One is from Paula Cooper Smith. Paula Cooper Smith is Mr. Roberts's neighbor, and she stated that he's been a very dependable, compassionate neighbor and a committed father. She also talked about an incident when there was a homeless neighbor who had recently passed away, that Mr. Stanley had located the family, arranged cremation, and organized a homegoing service so that our community could pay proper respects. His actions brought relief and dignity to our grieving neighbors. He also has a letter from his pastor of the TAM Outreach Community Center, Pastor Roderick Dennis, stated that he is his pastor and that he is a devoted member and a deacon of their congregation, and that he's known Mr. Stanley his entire life, and that he is a person whom he's seen grow deep in his faith. Your Honor, Mr. Roberts has not had any subsequent arrest or issues since the 2022 incident, some 3 years and 4 months ago. We are asking, Your Honor, respectfully to follow this negotiated recommendation, and I do believe Mr. Roberts will be successful if the court isn't so inclined.
All right, Mr. Roberts, anything you want to add?
No, sir.
The address at Gould Street, was that where you were living at the time? It sounds like you had a room in that space.
Yes, sir.
Okay, where are you living now?
That's where I live at. That's my home.
Oh, Gould Street is your home?
Yes.
Well, then we can't have you stay away from there. Do you own the house?
Yes.
You pause for a minute.
Mortals.
Okay, but the house is in your name.
Yes, sir.
Other people there were just your guests or
No,
people
they,
who,
they were friends, just me and my two daughters,
that's who lives in the Gould Street address?
Yes.
And your daughters are how old?
17 and 8.
8. You're the only adult in the household?
Yes.
Who cooks for them? You. What do they end up eating? Cereal?
Soul food.
Soul food. All right. Well, you need to stay at that address, so we won't say stay away, but you will be subject to a Fourth Amendment waiver, and so probation's gonna be able to come in that house, not in the middle of the night, but just kind of poke around and make sure, and that's not, don't need to have a gun. First of all, you can't have a gun. It's not, don't do that. You don't need to have drugs sitting around on a bureau with an 8-year-old around. 17-year-old would know what it is, but she shouldn't have to see that. So see what you can do. All right. I find there's a factual basis for your plea and that your plea is knowing and voluntary. Sentencing you pursuant to the Probation Options Management Act. Mr. Matthews, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Davis?
Yes, Your Honor.
And Mr. Roberts, is it okay if we electronically sign your name to the indictment?
Yes, sir.
We'll do that. The recidivist notice has been withdrawn. I'm sentencing you to count 1 to 3 years to serve 1 month, the balance on probation. Count 2 is 5 years to serve 1 month with the balance on probation. They'll run concurrently with each other. So a total sentence of 5 years to serve 1 month. You'll get credit for the time you already served. You'll be on probation for 4 years and 11 months. Special condition number 1 is to submit to a drug and alcohol abuse evaluation. And if that medical professional, healthcare professional says, hey, you should go to AA meetings or NA meetings or whatever it is, you're going to need to do that so that you are taking care of yourself, so that you can take care of your daughters. You also will be forfeiting whatever was seized that day. I know you, hopefully you haven't tried to get it, but the police are probably still sitting on that gun. You can't go back and get it. First of all, that would be illegal because you can't have a gun, but you're forfeiting that weapon. That's how we're going to leave it. But I am reminding you there's a Fourth Amendment waiver as part of probation, which means probation can show up and they don't need a search warrant to just say, hey, we're just going to walk around and make sure everything is safe and sound in here. Okay?
Yes, sir.
Any questions?
Sir.
All right. We're done with that. I need to go. Ms. Simpson is going to give you reporting instructions for probation. All right? We will be reconvening at 1 o'clock. Please be here at 1, and we'll take whatever pleas remain.
Judge, thank you so much.
Pardon me?
19.
Ms. Bernard? Hey, you've taken care of your case. I appreciate you being here, but you're on pretrial diversion, so you're good to go. Just take care of all the things you're supposed to do on that, all right? Thank you for being here. Pardon me? You want to get it on the record? Let's do it.
Mr. Roberts, can you verify your zip code?
30315.
Okay, so your reporting date is going to be September the 29th, that's coming Monday. You're going to report to the Atlanta office, which is 274 Drive. And I'll give you everything documented once we finish here, but you need to make sure you're there by 8 a.m.
Okay. All right. Thanks, folks.
All right. Thank you so much.
Hey, Ms. Rios,
Yes.
how are you?
Good, how are you?
Fine. Are we ready on Ms. Britton?
Yes.
Ms. Britton, you ready? Come on up. I appreciate your patience. Sorry, I'm a little late after 1. Good afternoon, Ms. Rivers.
Good afternoon.
You ready?
Yes, I'm ready.
Great. All right, we have positions 7 and 8 from our trial calendar. Both are Ms. Britton's cases. She is at the podium with her lawyer, Ms. Rios. Ms. Davis is the prosecutor. Ms. Britton, I guess there are 3 cases. There's one that's not on the calendar. So let's get all those indictment numbers. There's 23 SC 191639. That's position 7. There's 24 SC 005457. That's position 8. And what is our third case number?
It is 25 SC 004810.
4810. Okay. And if I go back to Ms. Rios's email, it's a plea to position 8, the case ending in 457. And then when you say diversion track for the others, meaning because all of this is going into accountability court, those 2 will be diversion track. And if accountability court goes well for Ms. Britton, the state's agreeing to dismiss those 2 cases.
Yes, sir.
Okay, so we're going to take a plea today only on position 8. And then the other 2 cases will be put on judicial hold while they're in drug court or BHTC, wherever this ends up, and we'll go from there.
Yes, sir.
Okay. Is that your understanding, Ms. Britton, of what we're doing? Correct. Okay. Well, in just a moment, Ms. Davis is going to put you under oath and ask you questions about that one case ending in 457. I may have a few questions as well, and you may have questions. Will you let me know if you have a question? Okay, great. Then listen to what Ms. Davis has to ask and answer truthfully, and we'll go from there.
Please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Right, yeah.
Okay, you can put your hand down. Please state your true, correct, and legal name for the record.
Anne-Marie Brittany.
Can you spell your first name for the record?
Eroi.
Ms. Rios, can you bend the microphone down towards you and your client? Thank you.
At this time, are you taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
I'm 20 and I done graduated from till 10th grade.
You said you went to the 10th grade?
Yeah.
Which high school did you attend?
Woodland.
Where's that?
That's in Stockbridge.
Is that where you grew up? Stockbridge?
Well, that in Atlanta.
Okay.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses? An indictment 24 SC 005457, aggravated assault and possession of a firearm during the commission of a felony and obstruction of a law enforcement officer.
Okay. Yes.
I'm sorry, can you say that again?
Yes.
Okay. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial.
Okay.
Make sure you say yes or no.
Yes.
Okay. Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, I have.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
Yes.
Ms. Britton, do you remember having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to this matter. Attorney Rios, are you aware of any outstanding warrants related to this case?
No.
Ms. Britton, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes.
Okay. For the aggravated assault, minimum of 1 year, max 20 years. For the possession of a firearm during the commission of a felony, it's 5 years consecutive to that. And then for the obstruction, just want to verify that's a misdemeanor, but I believe it is. Yes, and the obstruction charge is a misdemeanor, so it's a maximum of 12 months.
Okay.
Okay. Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes.
Do you understand the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has the right to sentence you to the maximum possible sentence?
Yes.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Attorney Rios, it's my understanding that your client is seeking to enter this plea under first offender. Is that correct?
Yes.
Ms. Britton, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty to or nolo to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced to for any crime, felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in the indictment?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yeah.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'd be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Okay. Yes.
I'm sorry?
You said, I know that?
Yeah.
Yes.
Okay. Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? And there's about 9 that I'm going to ask you about and then ask you, do you understand, okay? You're giving up the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
What does that mean?
Remember, I said, actually, when we talked about 4 years for habeas purposes, that means if you felt you were forced or anything, then that's a way to withdraw the plea or try to withdraw it. That's what you do by filing a habeas corpus petition.
Okay, well, then, yes.
Okay. How do you plead to the charges in indictment 24 SC 005457 to aggravated assault, possession of a firearm to the commission of a felony, and obstruction?
It's going to be guilty under Alfred.
Okay. Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea pursuant to Alfred? Is it your decision to waive these rights and enter this plea because it's in your best interest to do so?
Yes.
Is this plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes the evidence would show that on October 25th, 2023, at 4400 Bellwood Circle in College Park, Georgia, in Fulton County, officers with the South Fulton Police Department were responding to that residence in reference to a fight with a weapon. The caller was the victim, Mr. Jonathan Davis, who advised the female subject, later identified as Ms. Troy Britton, attempted to force entry into the residence and brandished a firearm. Officers of the South Fulton Police Department made contact with Ms. Britton, who was still on scene, who was standing in the front lawn with her personal belongings. She said she had previously stayed at the home and was attempting to regain entry to the residence. She did deny brandishing the firearm. However, the victim was able to describe it being a pink in color handgun that he saw as she was making threats towards him. The victim, Mr. Davis, stayed inside the house and then contacted the police. I believe that location appeared to be maybe a home that was not presently being lived in, and that others were basically occupying the residence. It's kind of like a squatter type situation. Our recommendation in negotiations with defense counsel is to have this case and Ms. Britton's two other cases go into behavioral health treatment court. We are asking for that sentence in this case to be 2 years on the aggravated assault. She did not shoot the victim. It's just a brandishing of the weapon, and 5 years, of course, consecutive for the possession of a firearm, and the obstruction to be 12 months concurrent with count 1. So we're asking for a total of 7 years probation for her to comply with all the terms of accountability court. So that's our recommendation.
And then stay away from not just the location you mentioned, but the locations that are linked to the two cases that will be diverted into accountability court if things go well for Ms. Britton.
Yes, and to stay away from the co-defendant in one of the cases and the victims in those cases as well. And just for the purposes of the record, and thank you for bringing that up, we are asking for Ms. Britton to stay away from the incident location here, which is 4400 Bellwood Circle in College Park, and no contact with the victim, Jonathan Davis. For her to have no contact with the victim, Kaylee Drehos, who was the individual who owned the car in that theft, and for her to stay away from co-defendant Corbina Palmer. The other incident locations are 100 Piedmont Avenue in Atlanta, Georgia, and 400 Dutch View Drive in South Fulton, Georgia.
Okay. You may have covered this. I missed it. If you did, the obstruction allegation in the indictment to which Ms. Britton is entering a plea is that she misled the officer about the gun. And I'm just curious what the factual basis is for that.
Yes, it was about making false statements about the firearm, but obviously officers were able to recover the firearm.
They got the pink gun.
Yeah, it was a pink
Okay,
gun.
got it.
Yeah.
Okay.
And so that's how they were able to corroborate what the victim said. It's not the gun.
Understood. All right, in terms of criminal history, what I see is 10 cycles, no felony convictions. Ooh. For the GCIC. That doesn't mean there are no misdemeanor convictions, just no felonies. Okay, got it. Okay, thank you. Ms. Rios.
Yes, Your Honor. Ms. Britton is 20 years old. She was trying to get her GED. She said she was before enrolled in a GED program, and she wants to continue that. She's been looking for a job, mostly as like waitressing jobs that she's trying to find. I do think this program would be good for her. She suffers from severe mental health disorders, and I think that's why she keeps recently getting cases. I know these cases are pretty close together, and before that, she didn't have much of a history. So I think something's going on mentally with her. But she does want to stay out of trouble. She wants to complete the behavioral health court program. And being that she's so young and doesn't have an extensive history, I'm hoping that you accept the plea as negotiated.
And what we know right now is that accountability courts have accepted Ms. Britton, but it's tentatively drug court with a likely pivot to BHTC, but that's just contingent on the medical records?
Yes, so they're just waiting on some. I know she got some yesterday and she only has to go up to Piedmont to get the rest of the medical records. And that's the only thing they're waiting on. They believe that she'll be accepted, so I guess they're gonna do an in-house I haven't had this situation before, but I guess they believe, just trying to get her in and then do the transfer.
We move people from one track to another from time to time if there's a good reason to do it. It's usually because there was an undisclosed or undiscovered mental health situation. Here, you're being very upfront about it. It just can't be documented. And without that documentation, you can't be admitted into BHTC. But once you get the records from Piedmont, as in Piedmont Hospital, is that where you're going?
I'm going to Apex. I'd go tomorrow at 11.
Okay.
And,
What's Apex?
it's like basically a mental health facility
Okay.
they have in Stockbridge, but I was once there and they got my records and stuff.
They've got your records.
Yeah.
Okay. And so you'll get that set of records and you know how to get it to, do you get it to Ms. Rios or do you have a contact with accountability court?
Brown told me to take it to her in mental health.
Good. Good. Ms. Brown is the right person to take it to. So what did you already get? Records from Grady?
I went to, it's somewhere around the corner from over here, and they do like the physicals and the plasma and all that.
Yeah.
And I had a scheduled meeting with them today because they was gonna do diagnosis too, but Miss Carla is not there, so
Okay.
they told me to come next week.
Okay. So you had an exam at Grady and then the results of that exam, do you have those or?
I have some of them, and they said they'll give me the physical paper tomorrow morning because they can't give it to me like the test results. They gotta get it in 2 days.
Okay. And then you'll get that to Ms. Brown?
Yes, sir.
Okay. And you've already had some kind of interview, was it with Ms. Brown or Ms. Wart or someone from?
I had an interview with Miss Brown.
Okay, great. Do you have any questions about anything we've discussed?
No, sir.
Where are you staying now?
Right now, I'm at my grandma's house.
And tell me what neighborhood is that in?
That's in Stockbridge.
Stockbridge. So how did you get here today?
I got here with an Uber.
That's expensive from Stockbridge to here. How are you, if you are doing accountability court, you'll need to go to Hope Hall, which is a building out near the jail. It's not near Stockbridge. It's in Atlanta, but you go there every day. How are you gonna do that?
Either they gonna take me from work, but they couldn't today because they had to go to work in the early, but
Who's they?
my aunt,
She goes to,
my aunt stay with my grandma and my cousin stay with my grandma's house. So,
okay, and when they drive to work, they could drop you off at Hope Hall?
yeah.
Okay, when do they work?
They work sometimes at 7 or they go in at 9.
Okay. And would you prefer to stay at your grandmother's house? Because there is supportive housing through accountability court, but you're in a rooming house and you have a roommate. That's different from staying with your grandma.
Cause me and Miss Brown, we had talked about
You
it
did?
and stuff. And I told her like if I wasn't able to, I'll let her know like ahead of time if I need to actually be inside, staying there like 24 hours every day, or if I'm gonna be my grandma's house and have it scheduled.
Okay, as long as you all talked about it. Just because Stockbridge that's gonna be a complicated commute.
Especially with the traffic.
Yep, yep, and it's every day. All right, I just wanted to make sure we were not setting up an impossible hurdle to get from Stockbridge to Hope Hall and back each day. But it sounds like with your aunt and your cousin, you all have talked about it and their work is somewhere in the Atlanta area?
Yeah, they work, my aunt, and they work at like the nurse, like one of these hospitals.
Okay, so they're coming up here anyway.
Yeah.
All right. Do you have questions about anything we discussed? Is it Mr. Palmer? Who is the co-defendant? How did you know Mr. Palmer?
That was my ex.
Ex.
Yeah, I was with him for like 3 years.
When did he become your ex?
I mean, after, when we came out of jail, when I got out of jail, because remember, you had me on the monitor and I was staying with his people and that didn't go out how planned. So I just told him, like, I'm done. Like,
Okay. So you knew him, I guess you were kind of young when you got to know him.
yeah. And that's a lot of reason of half these cases. So,
Okay. All right. Well, Ms. Britton, I find there's a factual basis for your plea in this case. Oh, talk to me about why it's an offered plea. An offered plea means that you disagree with some of the things the state says. And the state's basically saying you had the pink gun and you either showed it to, it says in the indictment, you actually pointed it at Mr. Davis. So you had a pink gun, you pointed it at Mr. Davis, and you were not truthful with the police about the pink gun.
it's he say, she say, and the police, they gave me the construction officer because they asked me for my ID and I didn't give it to them because I didn't know I had it on me. It was not about the gun. I told them where the gun was at. It was in my suitcase and I did not put the gun out on him at all. That's why it was he say, she say.
Okay.
He knew what color gun I had because I was staying with him previously. And then like, it's,
Okay. And Mr. Davis, this would be the different friend than Mr. Palmer.
yeah, that was his homeboy. So
Did you moved from Mr. Davis to Mr. Palmer?
no, I wasn't with him at all. That's what I'm saying. I went there to get my rest of my belongings.
Oh, Mr. Davis, got it. He was Mr. Palmer's friend.
Yeah.
Because he was around, he knew you had a pink gun.
Yeah.
Why did you have a pink gun?
For protection.
What are you worried about? Who's going to hurt you?
The men I be dealing with, so.
Okay.
You know.
You needed it for that.
Yeah.
Okay, I get it. You cannot have a gun anymore. While you are on first offender probation, which you will be for a few years, no guns, pink, black, silver, whatever it is. That'll be a violation of your sentence, and it's the kind of thing that could get you into a lot of trouble. So I don't say that because, oh, guns are dangerous. Guns are what people do with them. And if you're smart with them, then they're not dangerous. But if you're a first offender probationer, which you're going to be, it's illegal for you to have a gun. So I don't know where the pink gun is now, but it needs to get out of your life. And if there are any other guns in your grandmother's household, they can't be there because that's your household also. Does that make sense?
Yeah.
Are there other guns in that house? Not that you know of?
Well, no, my grandma don't have no guns.
Okay, but you gotta make sure your sister and your cousin don't have them either because they're not yours, but just say it ended up, it's on a table and probation's coming to visit and there's a gun on the table and it's your place, that could get messy for you. So there need to be no guns in the household. Okay. I understand why it's an offered plea then. So when I say there's a factual basis, it's a he said, she said. If the jury believed what Mr. Davis said and what the officer said, a jury could find you guilty. I'm not saying they would, but I'm hearing you say, I don't want to run through that. I don't want to run that risk. I'm looking forward to getting the support through accountability court. And I just soon not go to trial and instead go forward in the way that my lawyer has negotiated. Is that a fair statement?
Yeah.
Okay, then I'll accept your plea, which is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Davis?
Yes, Judge.
And Ms. Britton, we're only signing one of the indictments today because the other two are going to be on hold, assuming accountability court goes well. But can someone in my office sign your name to the offered plea in the case you are pleading guilty to?
Yes.
You have asked to be sentenced as a first offender. You qualify for that. You've been arrested a bunch for someone your age, but you don't have any felony convictions. And so you get a chance to take first offender. What that means is a couple things. The good part of first offender is that if you successfully complete your sentence, then there never was a conviction. You're going to leave here today under sentence, but you don't actually have a felony conviction. You're a first offender probationer. If you're applying for a job or trying to go back to school, you don't have to check that box that says, are you a convicted felon? Which is good, because sometimes checking that box means that opportunity is not available for you. First offender carries with it a risk though, and that is if you aren't ready to change your lifestyle and do things differently than some of the things you did over the last couple years, and you get arrested again for something, that new charge is a whole separate case, but that could trigger a loss of your first offender status. And without a trial, you'd have a hearing, we'd talk about it, but if the state could prove up that you did whatever this new thing is, I'll keep it simple. Let's say you got a gun again and it's just in your bag. You get pulled over, but you don't have a good license. And so they're going to impound the car and they take your bag and there's a gun in the bag. That's the kind of thing that not only is a new charge, but we'd get back together. And if I was convinced that you did have that gun, I could take away your first offender status and then you get resentenced. And you have just pled to 26 years worth of time, potentially. 20 for the aggravated assault, 5 for the gun, and a year, 12 months for whatever you said to the police officer. I'm not saying I would sentence you to 26 years, but I would resentence you. And I'm telling you now, if we're together again in a few months and you have slipped up in a serious enough way, I don't mean that you got a traffic ticket, but you got a gun, it's drugs, you stole something, forget about accountability court, that could be gone. But then I might be resentencing you and it's not going to just be to probation, because you would have shown that first offender was not a good plan for you because you weren't done with whatever these cases are all about. I just want to make sure you understand the risk or the downside to first offender. It's a great thing, but you are very young. You have led a complicated life, and it sounds like you have faced some challenges. And if you're not sure that you are going to be able to stay out of trouble over the next few years, then first offender can be kind of risky. Do you feel like you understand the things I just talked about?
Yes, I do understand.
Okay. Understanding those things, do you want to be sentenced as a first offender?
Yes, I do.
Okay. Well, you qualify, and I'll do that. So it's the sentence that I'm about to pronounce. It's a first offender sentence. For count 1, it is 2 years. Count 2, it's 5 years. Those have to be consecutive to count 1. And count 3 is 12 months. Those are concurrent with count 1. So it's a total of 7 years, all on probation. Hold on one second. You were in jail for a while. That's because there was a bench warrant?
Yeah.
Yeah, in the summer of last year. It looks like you were in for a couple months.
Yeah.
Okay. All right. So I'm going to change your sentence a little bit just to reflect that. So your sentence on count 1 is 2 years to serve 2 months. Count 2 is still that 5 years consecutive, and count 3 is 2 months to serve. So it's still 7 years, but the first 2 months are in custody, but you've already done that. And then the remainder is probation. So instead of 7 years probation, it's 6 years and 10 months of probation. Special condition of probation number 1 is that you complete an accountability court program. I'm not going to say BHTC yet because you're not in it, and I shouldn't say you've got to do something that you're not in yet because it's not going to be your fault if you don't get in. You are in drug courts. That's where you're going to start. As soon as those mental health records come through, if they document a diagnosis that, I'm making this up, bipolar or whatever, then you'll move over to BHTC. It's the same building, a lot of the same staff. It just, you'll be having a slightly different set of classes that you go to. But whether it's drug court or behavioral health treatment court, finishing it is a condition of your probation. That means that if you get kicked out or you quit, that's a violation of probation, and we'll need to work through what the consequences of that are. Okay?
Okay.
So you need to complete accountability court, and you need to stay away from Mr. Davis and Ms. Drejos and Mr. Palmer. Is staying away from Mr. Palmer going to work for you? I don't know if he is still someone important in your life.
I don't even know where he's at. Like,
Okay. Yeah, we need to sort out his situation. But you'll need to stay away from him as well, okay? And then those 3 locations, but then none of them is in Stockbridge and none of them is near Hope Hall, but they'll all be in your sentence. Your other 2 cases are going to be diverted into accountability court. So you're not entering a plea. If accountability court goes well and you graduate, the state will dismiss those 2 cases. And so you'll just be on probation for this case. And I'm not promising you that probation would be over when you finish accountability court, but oftentimes if accountability court went well, probation says, let's just wrap everything up because Ms. Britton's in a good place. But if not, you'll still have a few years of probation left when you finish accountability court. Ms. Davis, anything else for the state?
No, Your Honor.
Ms. Rios, for Ms. Britton?
I was going to ask for a behavioral incentive date. I'm not sure if you're inclined to do that, but it's first offender, so.
So first offender would make me less inclined, but 7 years is a long time. But I'm going to say no because I don't know how long accountability court will take. There are people who knock it out in 19 months, straight through. People who are eligible for BHTC tend not to rocket through quite as quickly. And I'd hate for there to be a conflict between the 2. So if Ms. Britton is doing well, a successful graduation from accountability court is often a signal to probation that something like a behavioral incentive date would make sense soon after that. And Ms. Britton will be getting to know either Judge Richardson, that's the judge who works on BHTC real well. She'd be in a good position to say, let's wrap up probation. Or if Ms. Britton stays in drug court, myself or Judge Krause. So we could certainly revisit that if accountability court goes well.
Yes, sir.
All right. Ms. Simpson, I have a question for you. When someone is in accountability court but on probation, are probation supervision fees waived because it's inactive, or are they having to pay whatever the magic step is that we agreed? Does that mean they're not having to pay the monthly supervision?
No, because technically we aren't supervised.
Okay. Because they're fees for accountability court, and I hope they're not having to pay both.
Yeah.
Okay.
So, no, it's because what it does is that when they're put into administrative status, they're like put in a whole system.
Okay.
So, they go back to the acts.
Got it. They're getting the clock is running.
Yes, the clock is running, but any, requirements are put on hold.
Okay. Got it. Ms. Britton, any questions about anything? So you're going to Apex tomorrow or you're going back to Grady tomorrow?
The Apex, Piedmont.
Okay. And that's in Stockbridge?
Yes.
So that's easy to get to from your grandma's house. Does your grandma drive? Do you drive?
Yeah. Well, I gotta re-get my L's because they was, with the situation.
I don't know with the situation. They took your license? Your license is suspended right now?
That's what they said.
Okay.
When I had that car incident.
Okay. But probably is suspended. Make sure before you start driving that you get the license back.
Okay.
All right. How many cars are there in the household?
It's 3.
3. Okay. Grandma, cousin, and sister?
It's my cousin and my aunt.
Aunt, I'm sorry, your aunt. But they each have their own car?
Yeah.
Okay. All right. Do you have any kids?
No kids.
Well, I hope accountability court goes well for you. It's a good opportunity. It fits nicely with this first offender situation. But you need to engage in the program. If you get distracted by other things that you want to be involved with instead, it'll get complicated. But we'll see how it goes. Ms. Simpson's going to give you reporting instructions for probation because I don't know that she has a start date yet for accountability court. Yeah. I know she doesn't because I've got the order of admission I need to sign. It just came through.
Okay, so
And she lives in Stockbridge.
she'll be, which side of Stockbridge?
Stockbridge, like Hudson Bridge.
So you're on Henry side?
Yeah, Henry.
Okay.
Why don't we not do a reporting date unless that's going to get you in trouble? Because drug court, accountability court's going to start soon.
Right, so that's literally how I was going to file this case, as, it's going to be filed under accountability court, so she won't even be required.
Okay, let's do that. Ms. Britton, orientation for accountability courts is every Tuesday. So I suspect next Tuesday you'll need to be at Hope Hall. But Ms. Brown, you have Ms. Brown's information. So you and Ms. Brown need to stay in touch. She will let me know if you disappear. So stay available for Ms. Brown and she'll be letting you know when you need to come to Hope Hall for orientation. Okay? If you don't have any other questions, then I think you're all set.
All right, thank you. Y'all have a wonderful day.
You too.
Us.
Ms. Britton.
Can I get your address so that we can have it on file? It's on, for, we just need some of this.
Ms. Britton, I'm sorry to interrupt, but I'm noticing you've got ankle monitor on.
Yeah, it just started about.
What case is that for?
This case.
Well, you got 3 cases, so I wasn't sure which one. One of the 3 cases? For the aggravated assault. How long have you had the ankle monitor?
I had it since March 9th.
Oh, because the bench warrant. Okay, that can come off now. You will get a different one. The first 30 days of accountability court for anyone and everyone, there's an ankle monitor. It won't be that one. It'll be a different one. So I don't want you to be like, wait, I'm done. Why do I have an ankle monitor? But that one, you should work with Second Chance. That's who operates the ankle monitors. And when you show them what's called your final disposition, your sentence, something that I'm going to sign today, and Ms. Rios can get it to you. If you show them that, they will take that off you. Okay? And it may be if what happens first is that Ms. Brown says, hey, come to Hope Hall. They may be able to take that one off. They'll get it to Second Chance, and then they'll put the accountability court one on. And that one automatically comes off after 30 days if everything's gone well. Okay? Ms. Rios, do you have other matters or was that it
That was
for you?
the last one, so I can see you, well, tomorrow, we have person, so I can see you in the morning,
We have
or not morning, afternoon.
afternoon. We're supposed to have a 4:14 all morning, but the defense attorney is stuck in trial in DeKalb.
No.
So Ms. Clark has to cancel flights for 3 people.
Darn.
Yeah. And it's all child molestation. I didn't want to hear it, but I had to hear it. So Ms. Wood is back Tuesday?
I believe it's Tuesday. I'm gonna double check. I didn't want to bother her while she's on vacation, but I could just text and make sure
Okay. And do you know when she's actually back in the United States? Because it's less of a bother. If she's here, I don't mind that you're calling her. If she is in Liverpool, then no one needs to be bugging her.
Well, right now she's in the UK.
Right. So I was saying Liverpool, like if she's.
Oh, so don't text her, you're saying.
No, you should feel free. There's nothing. I was just curious. You should figure out when she's coming back
Okay.
and let me know. So
Fine.
you can text her. I just didn't know when she was coming back
Actually,
stateside.
To try possibly.
Right. When could she have herself in 8D?
Okay, I'll ask her.
Okay. But I think she did wisely. Her leave includes Monday.
Yeah, I always do the day before and the day after too.
Judge's
Don't
notice.
remember that though.
Hmm?
Don't remember that.
No, judge's notice. It's very different when your leave ends on a Friday. That means, great, we can start things up on a Monday. But lots of lawyers like, my leave starts on Friday and ends on Monday with the
The time change.
yeah, whatever.
Yeah,
So
yeah.
come back on Saturday.
What?
Why would you
What
do
kind of
that?
vacation is this?
Yeah. Anyway,
I see
let
what
me,
kind of vacations you take.
let me know when she's gonna be back.
Okay.
24
and
hours.
If you are done, no, with a week in between, you just, anyway, we'll see you tomorrow afternoon.
Okay. By the way, get rid of that candy back there. It's all old. Like trying to eat that airhead and then I broke my tooth trying to eat that airhead.
Where do we have candy?
In the back in the drawer.
That lady knows she's been rummaging.
Yeah.
Miss Nelson, go back there.
I didn't,
Last Halloween, I heard.
yeah,
That's
ooh,
what the room
I didn't
is.
know that was stocked. Yeah, I wouldn't trust it either.
I do have one more. Mr. Amble.
Miss Rios,
Oh, yeah,
now
Mr.
tell the truth. You asked for candy. I sent you to the drawer.
I love it when the voice comes out of nowhere. Busted.
Mr. William Amble.
Yes, this one seems simple,
Yes.
but I want to hear from this. I understand the request.
Yeah.
So come on up, Mr. Ambles. You've got your sentence, you're on probation for almost 2 years. You were supposed to stay away from an address, and it turns out that you'd like to live there. And the reason why you needed to stay away from there has gone away because the person you were supposed to stay away from isn't there anymore.
He got his own place now.
Right. And so we need to confirm that, and I need to get the state's perspective on it because given your situation, it's complicated finding a place to live. You can't just move wherever.
Right. Yes, sir.
So, no, it's not your case, Ms. Davis. I'm just not sure if Ms. Nix had done her homework to see, because this motion was filed 3 weeks ago, if the state had any concerns about it.
No, we don't. So I just want to be, are we back on the record? Is this official?
We're not on the record. We're just talking about it informally. We may not need to get on the record if the state doesn't oppose it.
Well, my notes from Ms. Nix are that she was going to leave it to your discretion.
Okay.
Because he is registered and compliant, and she is not sure why there was a stay away order entered. But yeah, so she was just going to defer to you.
Okay. I appreciate that. Let's see. I'm not going to remember. I'll just see if there's anything in the docket that is explanatory.
Would you like me to explain? I remember what happened.
Why don't you start?
So he was initially, the reason why he failed to register is like police came to his house. His cousin, who he had beef with, was like, he don't live here because he was mad. So they got into like some type of fight. And so you were just like, well, just don't go back to that location because there was a fight. But now his cousin don't live there anymore. So.
Okay. So, but there's no charge involving beef with cousin.
No.
The charge is you weren't registered, or whatever address was in the registry wasn't the correct one. Do we know that the Cary Drive address is a compliant address?
Where it was last year, sir.
Oh, so it still is. You can't lose an address. If there's no park within 1,000 feet of where you live and then they build a park, you don't then have to move because you were already there. But I'm not saying anyone just built a park there.
Yes, sir.
Okay, so one of the conditions was let's just stay away from where you and your cousin had it. We waived your probation fees for a little bit, and then your probation can become unsupervised after 11 months. All right. So the request is modify the sentence to drop the location restriction.
Yes, but since we're here, I also filed the motion to make it unsupervised since I think we're at the 11 months now. Aren't we at the 11 months? Yeah, I think we're pretty close to it.
In 4 days. So I don't know that I need to do anything because in 4 days it ought to.
Automatically happens.
Well, let's ask Ms. Simpson. It says after 11 months of successful probation, the remaining probation may be unsupervised. So I don't order DCS to do anything. And I don't know if it's been successful. There may have been all sorts of Friday calendars that we weren't in.
That would have to be, I would need to check with my chief because initially our cases aren't eligible for unsupervised until 2 years, after 2 years of being on active probation.
Okay.
I would need to verify.
Okay. Well, please do check and point out what I put in the condition, but it also was may, not will or shall, because I know that is more of a DCS call, but it was part of the theme of Mr. Ambles's resolution is, look, if you do fine for that call it first year of probation, it doesn't need to be supervised the second year because it was a registry violation. It was I didn't keep them current with my address. But I see that if policy is 2, it hasn't been 2 years, and Mr. Ambles has a complicated situation because of his registry requirement. And that may be another reason why DCS would say we don't not supervise people in that situation. So I don't mean to make extra work for anyone, but if you check and see in 4 days, we'll be at the 11-month mark. Okay? Anything else?
No, thank you.
Okay. At a minimum, Mr. Ambles, I will enter an order that modifies your sentence to remove that restriction. Where are you staying now?
1639 Burton Drive.
What's there?
Morrow.
What is there? Is that a house?
It's a house.
Are you there by yourself?
No.
People you
My
know?
mom. Me and my mom.
Okay, that's your mom's place?
Yeah.
And what's at Cary Drive?
My oldest cousin owned that property. He just rent rooms out there.
Okay, and you want this more convenient for you to be there?
Yes, it's more closer to the bus line and all that.
Okay.
Because I'm in a program through probation right now, the Center of Employment.
Okay.
They trying to get me situated with, get my CDL license. And
So being on probation is actually a good thing right now.
well,
You don't want it to end
yeah,
early.
yeah, it is.
Okay, well,
'Cause
good.
I did get help with that.
Good, thank you, probation. But being at Cary Drive will just make it so much easier to get to the program that
Transportation and
probation has
everything.
found for you.
Yes.
Okay.
Yes, sir.
All right, I'll take care of that before the week is out. We'll get that sentence modified, and we'll go from there.
Okay.
Thanks, Ms. Rios, for bringing this to our attention.
So I can move back by the 1st. That's what I was planning on.
Yes,
First
you
of-
definitely can move back by the 1st.
Okay. Thank you, sir, so much.
All right, good luck.
Thank you.
Ms. Rockwell, oh, she was just here. She's on the phone. Okay, that's good. No one's gonna run away.
Hey, I'm not on the phone. You know, I'm in court right now with Dawn Bilal Skinner.
Really? The cupcake person?
Look, you know about the cupcake?
I've enjoyed the cupcakes.
But do you mind if I she's on Zoom. She's a prosecutor.
Whoa, do not kill yourself.
And I know y'all don't have any insurance either.
It's the county. We
You're
self-insure.
not even, hey, Dawn.
The worst kind.
Oh, she moved on. That's
Okay.
okay.
All right,
Just like every other man in my life.
or woman.
So, I don't want to get him nervous. Come on up here, sir.
Mr. Cook, is it better for you to sit or stand?
Be better off, I can see.
Sit, okay. If you would sit the table over where the young lady with the blue blazer is, she's gonna get you a chair. So let me provide context.
Okay.
Trial calendar, pick and jury Monday. This is where we are. So knowing that, what are we doing with Mr. Cook's case?
So besides stalking Ms. Davis, I've already also been talking with Adam Abate and Terrence on the case, just because we've had several chances to come back and all that.
Okay.
I can say with almost 100% certainty that this is not going to go to trial.
Meaning on Monday, we're not picking a jury on this case.
I don't think so. And if y'all have any kind of Zoom in the next 24 hours. So I've been provided, and I've provided more than one prosecutor with what's going on with him. Essentially, I think at this point, I could probably get up in front of you and get you to because we're so close together, without going into everything, but we're down to 10 to do 1. And based on this arrest, he was on probation for 2018 burglary in Walton County. And they revoked 16 months because of that.
So he had already done 16
Well,
months.
wait, that sounds great, except when he got to the jail, after 5 days, the jail kicked him out. Because
That's a good discount on 16 months.
it's a great discount, but there was a price tag attached. When he was 17 years old, he was standing in front of,
A friend,
but what was your apartment?
it's Oakland City apartment.
Oakland City,
Oakland City.
and he got shot
It wasn't
3
kids got
times.
shot at in that little baby video. It's in that same apartment complex.
Oh, okay.
2 kids got killed there.
So he got shot and he was in a wheelchair for 3 years and he learned how to walk again.
He made it across the room. That's great.
Right. And they told him he was never gonna walk, wasn't gonna have kids, this and that, all that. He also has a 19-year-old that's in nursing school.
So he had kids.
So he's got a golden child and she's down in Albany State. He is charged and we're so close together. I'm trying to get Mr. Miller to just fine tune that I didn't even get to
Overrule
tell.
his line prosecutor.
She's been real busy, Judge, so I didn't want to tell her what my counter was.
Okay.
And based on his medical condition, and I brought pictures of what's going on with his bottom. He's got a hole from an infection that has all the way to the bone.
Okay.
There's no flesh. And so the reason he got kicked out of the Walton jail is because the medical over there said not only that you might not make it, but you might spread whatever. So
How long ago was Mr. Cook to start his 16 months?
Well, when they took him out,
How long did they kick him out?
5 days.
No, right. When was that 5-day?
July 7, 2024.
Okay.
He did 16 months on house arrest. He had to stay in house 24 hours a day.
Oh,
So he's still, it's not that they said forget about it, they just said do it at home.
That's right.
Okay.
And he has to get permission to come to, and he's getting his ankle monitor off, so he's on house arrest. There have been consequences.
Okay.
So I think I could probably talk you or somebody into
Well, it's gonna be
new
me.
one.
The case isn't going anywhere else. It's gonna be Ms.
Well,
Davis. It's
I
with
know,
her.
but I did want to just throw that back at Madam Prosecutor or the supervisor, just everything going on. So
Okay.
he gets his ankle monitor off November the 4th, and he did it, I think, without a hiccup.
Yeah, I ain't needed no trouble.
Okay, that's good. Because I don't even know what would happen if he did get in trouble, but at least there's been some consequences, Judge.
How much house arrest is left?
November 4th.
Oh, the ankle monitor coming off is the end of the house arrest.
And then he's back on probation
Yes.
for a 2018 burglary.
Okay. Which looks like his last conviction. Because I've got the helpful criminal history here. That's a bunch of years of staying out of trouble until this case, which is actually not so new either. It's a 22 arrest. Okay.
So,
So are you wanting to go forward non-negotiated, or are you wanting to, Adam Abate is busy right now. You are
A
not
little
going to
bit, I
bend his
saw
ear.
that. I didn't want you to think I was anywhere but thinking about this, but I was thinking about it in the back row of the,
Of the closing arguments in that case?
and then I found out that they have a YouTube channel or
Yeah, it's being streamed. But yeah, that's what I would posit. Does Mr. Cook still have his final plea rights? So that, if we went non-negotiated today?
He does not.
No.
List-
sure because
Well, I'm not saying, it's not listed here. Let me see if it's,
Because then we could because she's already given a presentation of evidence. You could just on it and, yes.
that's what, because I don't know if you can do it. You was outside, remember?
Judge,
Yes, ma'am.
there's a go ahead on Mr. Evans.
Of having it become unsupervised? Okay, I don't need to make any I mean, his sort of said in his summer. Right.
It's already in his
Right.
original sentencing.
Right.
So,
And that's what I told Ms. Rios is, look, I've already made the recommendation. If probation wants to do it, I've encouraged it. Good.
Who lived in the house all Terrence's on
How often would you say supervisors are down in that space we saw?
oh, you know, supervisors, not supervising.
No, not probationers, but
Oh.
Goborn or Smith,
So
Franklin.
there's a schedule, we have what they call a manager on duty.
Mhm.
There's a schedule that is sent out the first of every month. Our chiefs pretty much have the same days unless they decide to switch up, but we have a schedule that everybody in the office has access to.
Mhm.
So there,
I'm just trying to sort out how much telecommuting happens, which is fine. I'm not,
there is
where are they?
supposed to be a manager in the office every day.
One.
Yeah, one.
Okay.
If it's more than one, I mean, great, but per that schedule, there's one.
Okay, I might be Monday, you're Tuesday, Deputy Gordon is Wednesday.
Now, that doesn't mean that they're not working all day.
Oh.
The other, young chiefs, the ones who are not in the office are virtual.
Got it.
But we have access to them.
But being virtual is A-okay. If it's not your day to be the on-site manager, there's no issue with being virtual. Okay, and it's looked like plenty of people use that option to be virtual. And they're still reachable. You get them on the phone, you can obviously email them. They're just not in their office. And if you're not the,
Unless it's we're calling
got it. How often do you have mandatory meetings?
We have one Monday with Chief Carlson, but aside from that, we don't have them that often unless there's been a change in the policy.
Okay. And does that apply to you and other specialists as well? That if you don't have court, you have an office, you could come in every day if you want, but telecommuting is okay. So there could be a time where there's really no one there. I mean, I guess there'd be the on-duty person, and you might have a few people in court, but all that space is empty. Okay.
Judge, and this is not gonna work out as a plea, I would ask that it be set tomorrow because this is a plea.
Yeah. Well, why don't we just put it to tomorrow afternoon? We had that 1 o'clock calendar. Okay. So if there's anything other than we're ready to go, let's just do tomorrow afternoon. If you're all right with that. Are you going to be here tomorrow afternoon? Do you have cases on that calendar? I didn't know if you had cases. Not 9 was that motion, the 414 that had to go away. So we could do it at 9, but I wouldn't want to make you come twice. I was just saying we do it at 1.
Oh, yes, it is at 9.
Hmm?
I said, yes, I agree. I'm sorry, at 1, I said 9.
Yeah,
At 1.
you agree coming once is
At
better
9,
than,
I was thinking, usually we would have had the other calendar at 9 too.
Yeah.
And that would have been hectic, that's where the motion would have went, but now
Right.
that we don't do it, now the motion's not done. So that's what I was thinking in my mind, but yes, 1 o'clock.
Judge, was the stay away, modified for Mr. Evans?
it will be. I'll enter an order and say striking that so he can move there. And he wanted to move on October 1, but I'm just going to do a new, I don't even know that I need to do, I'll talk with Ms. Nelson, whether I have to do an amended final disposition, probably so, rather than just an order that says he doesn't need to stay away from there anymore.
I'll email her and ask her to include me on the surface.
Yeah, I wanted to make sure it got to DCS. So, Ms. Rockwell.
Yes.
My answer is now that we'll keep the final plea rights out there. The reason why there were no notes here is that this came to us after final plea and non-complex. And so I don't know what happened there. It was a late transfer from non-complex. And so the first time it hit, it was an inquiry calendar. You got a little more discovery. And then this is the second and final trial calendar for the case. So there really, in this division, there never was a final plea, not final plea, because we had the inquiry and you said, Judge, you can put it on a trial calendar. And we did. And so here it is. But I'm comfortable saying whether we do it now or I have a calendar at 1 o'clock tomorrow. So tomorrow afternoon, if you need to do more of your shuttle diplomacy with others in the DA's office, we could just reconvene at 1 tomorrow. I'm good either way.
Is there any way that I can do that on Zoom?
You don't have to be here. It's helpful to have Mr. Cook here, but I don't like imposing, it's hard for you to get around.
But he's happy because he's out of the house.
That's right.
Oh, you like being out of the house?
I do get to come out when I keep coming to court.
Are you on house arrest?
Yes, I can't come out the house unless I call and let them know I'm going somewhere. I go on to a doctor appointment, I go to church on Sunday.
Because of your bond?
No, because
of his revocation.
Oh, because of your Walton County, whatever it was.
I've been sitting on the porch over a year.
Oh, no wonder okay. Huh. That's a lot of porch sitting.
Yeah.
Maybe that's why he's got that.
That's what I was saying. No wonder. So.
Come sit here.
No. He can stay seated.
I don't have no problem.
Okay, I just didn't want to keep you standing for a long time.
I didn't want to keep sitting because it hurt.
Oh, well, then you should have said stand. I said let's stand. We can take care of things now. If they're not ready now, then it would be tomorrow. We have a 1 o'clock calendar, but you'd need to be here. Ms. Rockwell would be on that screen right there, so she'd be there with you, but it would be virtual, and she'll look like this law student because there'll be all these fake books behind her. But she'll be on the screen. And I'm all right with that as long as you're all right with that.
I want to do whatever she tell me to do.
Well, that's risky.
I'm gonna maybe figure out a way to get back here because I'm just waiting for my prosecutors
Yes, ma'am.
to.
The prosecutor sitting here.
Right, there's this one here who soon enough is gonna be a supervisor, so.
I always tell my prosecutors when I.
That's smart because it chaps them if you don't. Well, here's what we're gonna do. I talked to your boss.
Well,
So it's why it's good you tell them that.
well, but most of them say, that's fine. Go talk to
Go do
my
it.
supervisor.
All right, so 1 o'clock tomorrow.
Yes, sir.
All right, can you be here at 1?
I ain't got no choice.
Good answer, but
When Judge Roberts said be there, I'll be there.
all right.
I'll be watching you on YouTube at home. You don't know that.
Well, we're gonna have a trial next week, so you can watch that.
Yeah.
Judge Judy and Judge Robert.
Yeah, you're such a good judge.
Hey, thanks. Don't butter me up yet. You haven't heard what your sentence is gonna
I
be.
watch you. You ain't like the rest of the judge. I've been doing crime all my life. Not right with the judge. You listen to both sides.
All right,
Take it from both sides. You want to just go on one side.
you're right.
Listen from both sides.
That's what you're supposed to do.
Someone got something to say, and they say it to you, you'll take it in consideration. You will.
Amen.
I'll sit back and watch you do it.
All right,
Sit back and watch you do that.
you gonna get home safely?
Yes, sir. My wife right out. You get in the car with her and I'll be here tomorrow.
All right, she likes Nickelodeon.
Yes, you do. Y'all have a good day. Good.
All right, what time tomorrow?
1 o'clock.
Thank you.
That's right, well, please.
I will be here. No
I
problem.
guess
I will
we're
be
you
here.
up there.
I will be
You
here.
have a second page.
I know.
So I need Abate focusing on getting ready for trial next week. Don't bug him. Bug Terrence.
Oh, no. Terrence, and he was in a.
She attacked
So-
the person.
so this
That's what I
was-
heard.
This,
He jumped out.
no, they started in the
Say-
parking lot.
Excuse me.
But I can tell you, there's some really crazy things. My phone must have heard your name, so look. Oh, look what pops up,
That's hilarious.
look. And you're such a character. Look at all the, that's from, Brewas.
Yeah. Farewell to Rewa. A contractor. I know. I've seen it. That was
Good job.
revolving door.
You got on.
So that's when, Judge Dempsey's next door, right? So you might as well, once you just go get that mailbox.
Ms. Rivers, we are done for the day. Thank you. We will see you virtually tomorrow at 1.
Okay, Judge, have a good afternoon.
Thank you. You too.